Good morning, everybody. Happy Wednesday. It's TCF Live, episode number 298 this morning. My name is Dan Soul. I will guide you through this 3-hour journey through Courtlandia. We will start with Judge McNally.
Your name, ma'am? Good morning. You're charged with stalking. They say you stalked the victim near a listed location on Montebello near Albert after being advised not to do so. You're charged with that offensive. No, have a seat, sir. With the offense of stalking, and you have the right to a lawyer. Would you like a lawyer? Yeah. Okay, so you go out in the hallway. We'll set you up with the defense lawyer. Mr. Conley, will you? And either way, you're coming back in front of me with your lawyer. Okay? Or what's Mr. Gate doing?
He's Judge Dustin.
Okay. Michael Edward Patrick, 2672873 A and B. Good morning. Your name? You're charged with operating while intoxicated. You have the right to an attorney. Would you like an attorney?
Yes, sir.
Okay, we'll set you up with a defense lawyer. So you can go out in the hallway. We'll give you the defense attorney. And then either way, you're coming back in front of me after you speak to him and after he speaks to the prosecutor. Okay?
Yes, sir.
Thank you. Adams, Danielle, Yvonne Adams, 267842460 A and B. Your name?
Danielle, Yvonne.
Charged with driving on a suspended license. I can do, and no proof of insurance, an expired plate. And either way, you have the right to an attorney if you want one, either that, or I can arraign you and send you to the prosecutor. It's up to you. I can't hear you. So you're going to waive your right to a lawyer and have me arraign you?
I'll get an attorney.
Okay, we'll give you an attorney. You go out in the hallway, we'll set you up with a lawyer, okay? And either way, you're coming back in front of me. People against Hart. Dustin Lee Hart, 267841057. Where were you? Your name?
Dustin laid out.
Where were you?
Just taking pictures to show.
Hang on.
Cleaned up,
What happened here, Heather? He did not show up on the bench trial date, did he?
And Dustin Hop, I believe he's scheduled for. Let me look here, Judge. I'm pulling
He's
it
up for
right now.
He's up for a bench trial today. Okay.
And then, yes,
Did you have a lawyer or you just were?
roper.
Okay. So I'm going to go ahead and send you to the prosecutor. You guys figure out if it's going forward. If it is, we'll start the trial. Okay? Thank you. So we're just going to send it.
Okay, so he's gonna come in like soon.
Good.
Okay.
Here. Let's go to the
Yeah,
prosecutor. Anything else out there right now, Heather?
we do. We have Mr. Vaughn, that one you had coming back for the hearing. I just chatted John to put that file up.
What is it?
Dwayne Vaughn, that hearing file, the manila envelope.
Give me 1 second before you bring them in, will you please?
Yes.
Alrighty, good morning once again, everybody. It is TCF Live Wednesday, episode 298. Good to have you all here. It looks like Judge is in a little bit of a pause mode. Let's move on then. We will go to Judge Anzalone. Say good morning to her.
Fry, we're back on the record in file number 2025-22446FH. Mr. Fry with Mr. Wade and Mr. McCready on behalf of the people. So Mr. Fry, how would you like to proceed today?
Yes, Your Honor. So we do have a plea agreement in this case. My client, he got a different phone number, so I wasn't able to reach him before the hearing. So he hasn't signed the advice of rights, but he's in the.
We got one for him.
Perfect. So that needs to be signed. But the plea agreement in this case, Your Honor, is that he would count 1 would be dismissed. He would plead to the added count 2, which is the misdemeanor larceny, $200 to $1,000, and there would be a sentencing agreement to no immediate jail.
All right, is that correct, Mr. McCready?
Yes, it is.
Okay, so read through that, Mr. Wade, and when you're done, sign it. Okay, so Mr. Wade, you've signed an advice of rights and I'm going to receive that back and then I'm going to go through them with you on the record, okay?
Okay.
All right. All right, so Mr. Wade, I'm going to need you to speak loudly for me. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Speak louder.
I do.
Okay, very good. Now, Mr. Wade, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention today to plead guilty to count 2, larceny 200 or more, but less than 1,000, which carries a maximum penalty of up to 1 year in jail and or a $2,000 fine, or 3 times the value of the property stolen, which is ever greater, with an agreement that would be no upfront jail? Is it your intention to plead guilty to that charge?
Yes, ma'am.
Sir, you gotta speak up.
Yes, ma'am.
You kind of almost gotta, like, some people are soft-spoken, attorneys are not soft-spoken, so you kind of gotta yell it for me, all right? Our courthouse is old and the recording system's bad. So is it your intention to plead guilty to that?
Yes, ma'am.
Okay. Now, are you satisfied with Mr. Fry as your attorney and the advice that he's given you?
Yes.
Okay, and neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. McCready?
Correct.
Is that correct, Mr. Fry?
Yes, Your Honor.
And Mr. Wade, other than the agreement on the record, no one's had a discussion with me about that. Is that correct?
Correct.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial. And if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you had been convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that? I'm sorry, can you repeat that?
Yes, ma'am.
Okay. Do you understand that if your plea is accepted and you engage in any misconduct as defined in MCR 6.310, between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea? Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms and conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So you understand if you don't show up at sentencing or you get charged with a new crime, that I could put you in jail at sentencing because the plea agreement wouldn't be valid anymore. Do you understand that?
Yes.
Good. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right. How do you wish to plead to the charge that on or about May 15 of 2025 in the city of Hudson in the county of Lenawee, that you did commit the offense larceny 200 or more, but less than 1,000? Guilty or not guilty?
Guilty.
All right. And has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is prosecutor or defense counsel aware of any promises or threats or inducements other than the plea? All right, so MDOC, I'm gonna have to put you in the waiting room. So MDOC, I'm gonna put you in the waiting room and I'll bring you back in a minute, okay? Because I'm getting background noise. All right, has your attorney promised you any particular sentence or estimated what your sentence will be other than the agreement?
No.
Okay, and it's your own choice to plead guilty.
Yes, ma'am.
Okay, and I know I went over this, I just don't remember. On May 15 of 2025, we're in the city of Hudson in the county of Lenawee.
Yes.
And at that time, did you take a Cherokee Arctic Wolf fifth wheel that belonged to Christopher Allen Willis?
Yes.
Okay, would you agree the value of that property was 200 or more, but less than 1,000?
Yes.
And did you have permission to take it?
No.
Okay, and when you took it, you meant to deprive him of the value of it, correct?
Correct.
Say it louder.
Yes.
Okay, good. All right, are you satisfied, Mr. McCready?
Yes, Your Honor, thank you.
All right, has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes,
And Mr. Millar or Mr. Fry?
Yes, Your Honor.
Okay. All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Ms. Adams, I'll need a notice of hearing for sentencing. This court has made no agreement other than the no upfront jail regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them because of the Killebrew agreement. I'm going to refer this matter to the district court probation department for a pre-sentence investigation. So this is a misdemeanor. So you'll have to go to district court probation, okay? Now I'm going, Mr. Fry, are you available July 17 at 8:15 in the morning?
Yes, Your Honor.
Okay, I'm gonna set this for sentencing July 17 at 8:15 in the morning. Mr. Wade, not tomorrow, but next Thursday, which will be June 4. I need you to report to the district court probation department between 8 and 10. Can you do that?
Yes.
And when you check in, just tell them you pled to a misdemeanor and they'll do a pre-sentence interview with you, okay?
Okay.
When you meet with them, be truthful about the events that occurred, your background. They'll prepare a report and a recommendation. We'll provide a copy to Mr. Fry. He'll reach out to you and review that with you. Make sure that if you change your number again or something, you keep him updated on what your number is, all right? And do you want to appear in person or via Zoom?
Zoom would be easier.
Okay, I'm gonna give you, or my bailiff's gonna hand you Zoom instructions. And that's how you'll call in. And then if you will have a seat behind you, we'll get your notice of hearing for sentencing, all right?
Thank you.
All right, thank you. Miss Adams, I'll have them sit on the bench. Okay. So. All right, we are back to Mr. Bowerman. Hold on. Mr. Fry, you had,
Have Chad Marvin, I think, is the
do you want
only.
to break out room real quick?
Sure.
Okay. Hold on. take care of Mr. So Mr. Marvin, I'm gonna put you in a breakout room with Mr. Fry. And then you can chat with him for just a minute while I take care of Mr. Malaro's next case. All right, go ahead and join that breakout room. Okay, so we are back on the record with Mr. Bowerman. So sorry, I got to read the file numbers again. 2025-22242 FH, 2025-22243 FH, 2025-22277 FH, 2025-22469 FH, and 2025-22479 FH. Matter of the people of the state of Michigan versus Gary Bowerman. So, Mr. Malaro, how would you like to proceed today?
So, Your Honor, I've resolved my concerns with Mr. Bowerman and whether he wanted to represent himself. He does not. That being said, I would ask if we could adjourn this perhaps 2 weeks for me to see if we can get this matter resolved in one fashion or another.
I do have one slot available for June 10. Is that too soon?
That'd be fine, Judge.
All right. I will tell you, Mr. Malaro, because of the volume of files, I will set it for pre-trial on June 10. But if he decides to avail himself of a plea, please let us know and I'll sneak him in on another day so that we have more time.
Yes, Judge, we'll do that.
And I'll have you do the step in order to adjourn. Mr. McCready, can you sign your name with permission?
You may.
All right. So Mr.
Thank you,
Bowerman, we will see you back on that day. Thank you.
All right, thank you guys. Have a good day.
You too. Thank you. All right. So, find out. Where's that in there? Look at
Willie Johnson.
Oh, is it Willie Johnson? All right. I think he has Rhonda Underwood. Are you Willie Johnson?
Yes, ma'am.
Well, good.
Yeah, Willie Johnson's my
see
client.
you. Good morning. Mr. Malaro, do you need a breakout room with Mr. Vila?
I do not, Judge.
Okay, so Mr. Vila, bear with us for a moment. I'm gonna take Mr. Johnson because he's with MDOC. All right, so FGHIJ. Okay, so this is file number 2021-20392 FH in the matter of the people of the state of Michigan versus Willie Lewis Johnson Jr. So, I have Dave McCready appearing on behalf of the people and Matt Murphy appearing on behalf of Mr. Johnson. And I think if I remember this, we need to set him for trial again, correct? Or what are we doing today?
Your Honor, could I have a breakout with Mr. Johnson, please?
Yes, you can. So Mr. Johnson, I am going to open up a breakout room. I believe that you are on a Polycom. So you should go automatically to that breakout room. When you're done talking to Mr. Murphy, I will bring you back in, all right? No, he's already gone. There you go. He was on Polycom. All right. So, let's get Mr. Vila's file. Mr. Vila was trying to get me to bond him out. All right, this is file number 2025-22210 FH and 2025-22368 FH. This is in the matter of the people of the state of Michigan versus Israel Vila Jr. All right, so Mr. Vila, I received a letter on April 28th from Mr. Vila. He was asking for removal of his public defender. He said there's been a breakdown and conflict in your case, and he would like to request William Amadeo as his public defender. He has agreed to take my case and would again ask that this court grant my request. So I'm going to summarize something really quick, Mr. Vila. And, you know, back in the day when I represented you, I was a public defender, right?
Right.
And so we had a contract with the courts, right? And so the courts could grant you another attorney if you ask for it, and they would do it one time because we were a direct employee of the courts, which kind of was not a good thing, right? Because, you know, they found that maybe attorneys shouldn't be beholden to judges. So we were very fortunate in our county that they were forward thinking and allowed the funding for an independent public defender's office, which we have. Which also though means that I have no authority to remove an attorney or appoint an attorney. So that's a good thing because I can't pick and choose who represents you, but the public defender's office is appointed and they, you know, obviously have a process for that. So I can't grant your request. So I just wanted to put that on the record. All right. So that being said, Mr. Malaro and I have Allison Arnold appearing on behalf of the people. Mr. Malaro?
Yeah, Your Honor, so I did review that letter. I don't know what the breakdown would be, but that being said, we've already provided Mr. Vila with a second counsel, that would be me. We are bringing on a new chief in a couple of weeks. So I would ask to adjourn this to see what the new boss says about whether Mr. Vila gets the counsel of his choice or someone within our office. I'm just saying I'm not certain how our office is going to handle these kind of things in the future, and I'd like to wait until that new person comes on board so we can establish whatever that policy is going to be.
So
So
Mr.
I'd
Vila?
ask to adjourn the matter.
All right, so Mr. Vila, they have a new boss at the public defender's office, girl power. And Mr. Malaro, once again, is surrounded by women who boss him around. So Mr. Vila, because they have a new boss coming in, their policies may be different. And so Mr. Malaro would like to adjourn this a couple weeks to see what their policies are going to be. Do you have any objection to that?
No, I don't.
All right, and Mr. Malaro, what's her name?
Yeah, I don't actually know.
I
her
do.
name,
Can
Judge.
I say one thing though?
guess
Can I
what
say
her
one
name
thing?
is, but I
Okay,
don't know.
everybody stop talking.
Hey,
What, Mr. Vila?
man, tell the prosecutor, man, the prosecutor, lower that sentencing, man. I'll take a plea. Tell her to work
So,
with me, man.
Mr. Vila, if the only reason you want to fire your public defender is because
Hey,
you
listen.
don't like the plea offer.
I'm
But
not.
anyway,
Listen, it's not about
Okay.
that.
Okay, all right.
I'm
So,
talking about the
Mr.
prosecutor.
Malaro, when does the new chief public defender start?
Oh, the 8th of June, Your Honor, so if we could do that sometime that week, that'd be
You said the
Yeah,
5th of June?
8th of June.
All right, why don't we do June 17 at 8:30?
Hang on one second. I'm not here on the 17th. I don't know how much difference that makes. It might
that'd be
make
a great-
sense to go.
That would be a good date, Judge, if she's not here.
It might make sense to go to the 24th. And
Great.
Judge,
June 20.
for the record, the new public defender's name is Christine Beecher, and we are glad you were on the mend.
Well, I'm not. So,
Well,
I'm
hopefully
working
soon.
on it though. I'm hopefully soon. All right, June 27 at 8:30. Mr. Malaro, can you do the stip in order to adjourn those?
Yes, I can, Your Honor.
The
I thought it was
24th.
on the mend, but it's kind of going back downhill.
Did you say the 27th or the 24th?
Saturday.
No, we don't want to do Saturday. How
No,
about
we do not.
June 24? June 24. Sorry. Okay. All right. There we go. All right, Mr. Vila, we'll see you back then. Thank you.
Thanks, Judge.
All right.
Well, that does explain one thing for us. We actually had somebody ask in a comment on one of our videos here on TCF where Judge Anzalone's been, because we haven't seen her in a while. Sounds like she was ill and might still be, so that explains that. Good morning once again, everybody. TCF Live on a Wednesday. Let's go to Lake County, Ohio. A certain Judge O'Donnell is about to deal with a new contestant.
Ohio versus Nathaniel Jackson, case number 25 CR 1652. The defendant is present with counsel Paul Meyer. We were last here on April 10th, 2026, where the defendant pled guilty to count 1 of the indictment, failure to comply, a felony of the 3rd degree, and we are here today for sentencing.
All right, Mr. Meyer.
Your Honor, that is correct. I think the court is also aware of the fact that Mr. Jackson has been sentenced by the Cuyahoga County Common Pleas Court for a period of incarceration with ODRC, on a similar charge. So we're ready to proceed with sentencing.
All right, go ahead.
Well, Your Honor, I would like the court to fashion a sentence which includes a minimal amount of time. I think Mr. Jackson has been relatively cooperative in this matter. He's already got a lifetime suspension of his operator's license, so I know the court would also impose that overlapping suspension, and then I believe any sentence the court imposes is by law going to be consecutive, so we understand that. Thank you.
All right, Mr. Jackson, what do you want to tell me before I impose sentence?
I just want to let you know that I am better than my worst moments. I'm not like trying to go to prison for a longer time. Like I was hoping like for like a suspended sentence if possible. But I'm owning up, taking responsibility for my actions, and just ask for your mercy.
So what was the thought process here when you were at this?
I wasn't
behind the wheel in this Willoughby case.
I honestly wasn't thinking. I was scared at the time. I was really just scared and trying to get away at that moment.
Well, the problem is the getaway. What time of day was this? Do you remember?
It was nighttime. Well, evening.
Okay. People around in the shopping center?
They've said that, but not yeah.
Okay. So you essentially turned a misdemeanor theft case into a felony 3, flee and elude. So why did you decide to run?
I was scared. I was on probation in Cuyahoga County, so I was scared that I was going to get arrested and they were going to violate my probation and stuff like that. And I just knew that I was doing something wrong, so I was trying not to. I was trying to evade the law and not try to get in trouble at that time.
Well, you've been sentenced out of Cuyahoga to a year for a failure to comply, right?
Yes.
Right. And what was that failure to comply all about? What'd you do?
We actually got. They said that they tried to conduct a traffic stop, and I didn't see them, but I pulled over a little bit further down, and they came like about 5 or 10 minutes later, and they addressed me about the situation, and we handled it right then and there. I went to jail, bonded out, and then.
Okay, you've also got some attempts in your past, right? Failure to comply?
Yeah.
Okay, why do you keep doing the same thing over and over again?
Honestly, I'd be scared to stop for the police, but now I'm just not
Why? Why?
Most of the time I'd be on probation, or it'd be something going on in my life to where I just don't be feeling like jail is like the right thing at the right time, at that time.
Well, it's usually never the right thing at the right time, right?
No, it isn't, but now it's like, now I know not to do that. I can't drive anymore.
Well, this situation, you went over a median, one point, went a little airborne, and then nearly struck some pedestrians.
I understand.
That's people. Target's a busy store. There's people in and out of that place all the time, and you nearly hit some people. So your past demonstrates you don't have a lot of concern for this kind of stuff, because you've got Is it, Ms. Gold, is it 2 attempted failure to comply in the past?
Yes, Your Honor, one in 2023 and one in 2025.
Okay. And then we got the Cuyahoga, then we have this one, go ahead.
The one from 2025 was actually in 2023.
Okay.
It was the same one. It was a duplicate charge, and I was supposed to get charged for it. And when I got out of prison, William McGinty, he missentenced me at the time, I'm guessing. And when I got sentenced to prison, he was supposed to put that in there, and he didn't. So when I got out, he just gave me probation for it. But it was from 2023.
Okay, well. So on the first attempted failure to comply, you went to prison?
Yeah.
Was that McGinty also?
Yeah.
Okay. And then you got the minimum on the Cuyahoga one, the 12-month, right?
For this here?
Right. When you were downtown?
Yeah, that I'm serving, yeah, no.
Okay. You're going to Lorraine in a couple weeks for sentencing on a theft, right?
Yeah.
And we got some Summit stuff you got to take care of, right?
Yeah.
All right. You got to get your shit together. I mean
Yeah,
this is ridiculous.
I understand, Your Honor. I have court on Friday, actually, for another case that I'm trying to clear.
Where, Summit?
I believe so. I think it's Summit. I'm sorry, they run together. I'd be confused. But it's from prison. I'm in prison now, so it'll be from there.
All right. Well, you got to figure out what you want to do after you get out of prison, because this stuff ain't working out too well so far.
I actually was working when I got, and then I have my son, he was born February 11th, so I haven't got to see him yet either. But I was actually working when I got arrested. I just was doing dumb stuff.
Well, that's true. Can't argue with that. Anything else you want to say?
Your Honor, I just ask that you give me the minimum, if any prison time at all.
Well, there has to be prison time. That's the nature of the offense. When you pick up these failure to comply, it just compounds. So it has to be a prison sentence, and it has to be consecutive. So that's where you're at. That's kind of the activity you engaged in.
I understand.
All right. Ms. Gold?
Thank you, Your Honor. In this case, as you have already said, the defendant essentially took what would have otherwise been a misdemeanor theft and escalated it to a failure to comply. This offense happened at approximately 6:30 in the evening on October 27th, 2025, so a few days before Halloween. And at that time, the parking lot where the Spirit of Halloween store was located was busy with pedestrians from Spirit of Halloween, from Target, from several other stores. And the defendant, with no regard to the safety of any of the other pedestrians or people located in those cars, took off with disregard to those people, driving across a median, driving through a pedestrian crosswalk. Parents had to pull their kids closer to them. There were individuals who the police talked to who were afraid that the defendant's car was going to strike them. And the defendant took these actions with no regard for their safety. The defendant has previously been convicted of what shows on the Cuyahoga County docket is 2 attempted failure to comply, one in 2023 and one in 25, as well as a recent conviction for failure to comply F3 that he was sentenced to in Cuyahoga County. The state does not believe that these actions warrant a minimal prison sentence. The state is asking for prison consecutive to what the defendant is serving in his Cuyahoga case.
And that is consecutive by statute, correct?
Yes, Your Honor.
All right, I reviewed the pre-sentence report that was done out of Lorraine, as well as a portion of the report relating to this offense, and reviewed the judgment entry from Cuyahoga County from your recent sentence. I considered all the provisions in 29-29-11, 29-29-12, and 29-29-13. So, as I said, Mr. Jackson, this is usually these failure to complies are on streets that lead to highways and 90 miles an hour and the police stop chasing, but this was, I think this was more dangerous because now we're not talking about cars, we're talking about people walking out of stores across parking lots at 6:30 at night, 4 days prior to Halloween, so it's busy. And that place is always busy. That shopping center is always busy, especially around that particular area. So you pose a real danger to people who are just out minding their own business because you're, and these two other women are, you know, doing what you do, and that's, you know, stealing from different stores. That's, you're all over the place doing this stuff. So on this charge, count one, the failure to comply, I'm going to sentence you to 24 months in prison. And that, by statute, that sentence is consecutive to your Cuyahoga County case, which is a 12-month sentence. I'm also going to impose the costs, and your driver's license is suspended for your lifetime. That's a mandatory suspension under the code. When you get out, you will be on post-release control for a year, up to 3 years, with conditions. If you violate the conditions, a parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. If that violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months for the time left under post-release control. The remaining charges are dismissed.
Your Honor.
Yeah.
Am I able to get the time served for since December? Or I got arrested December 16th from Lake County. The U.S.
Well,
Marshals came.
I do not believe so. I don't know Ms. Gold's position on this, but you're held on several other cases. So I don't know if you believe there is any credit for time served.
Your Honor, I don't believe there is because at that time he was also being held and getting credit for.
Okay, if you are, we'll take a look. If you are not being held on anything else, then I'll give you credit. We'll go back and give you credit for whatever time you served. But if you're being held on something else, then there is no credit.
So can I get like a judicial or something?
Well, you got to clear up a whole bunch of things before you can even think about that. So, anything else, Ms. Gold?
No, Your Honor, thank you.
Mr. Meyer, anything further?
No, Judge, thank you.
All right, we're adjourned.
2 years on top of a year.
2 years consecutive to the time that was imposed by Cuyahoga County. You had 12 months from there. Now you've got 24 months from here.
So I don't get out to 2009.
Yeah, I would say that's correct. And, you know, I'll look into.
All right, always fun to hear a little bit of back and forth between attorney and client there. Let's go back up to Judge McNally.
2071. Good morning, sir. Your name? All right, so you were arraigned on April 15th. You've been representing yourself, correct?
Yes, sir.
And you met with the city attorney today, and they are going to dismiss the driving on a suspended. You're going to plead guilty to allowing an unlicensed driver to drive. Is that right?
Yes, sir.
If you do that, the possible penalties are up to $500 in fines, 90 days jail costs, or all those. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you're giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
You still have the right to a lawyer. If you want one, I will appoint you one. Would you like a lawyer?
Really? And the prosecutor settled the plea bargain?
Well, I know, but I have to tell you, if you want a lawyer, I'll give you one.
No.
Do you understand that?
Yes, sir.
All right. So you want a lawyer or you don't want a lawyer?
No, sir.
You waive your right to a lawyer? The charge allowing an unlicensed driver to drive, how do you plead?
Guilty.
On the 20th of March at 26 at 9:10 p.m., were you in control of a 2009 Chevrolet that was being operated on Allen near King in the city of Woodhaven?
Yes, sir.
Did you allow somebody to drive that was unlicensed?
Yes, sir.
And that was you, correct?
Yes, sir.
Are you licensed now or taking steps to get a license?
Taking steps to get a license.
You got to do that. Why didn't you ever get a license? You're 27, right?
The Secretary of State here told me that I can take care of 2 traffic violations back home in Las Vegas.
You moved to Michigan from Las Vegas?
Yes, sir.
Are you on probation or parole right now?
No,
Anybody force you to plead guilty?
no, sir.
I'll accept the plea, dismiss the system, we'll light on you, but you gotta stay with me here. I mean it, don't come back on one of these, okay?
Yes, sir.
You go take care of those tickets in Las Vegas. They'll let you up here by Zoom if they're misdemeanors or pay them up if they're civil infractions. I don't know how old they are, what the circumstances, but you need to check into that and follow up, okay? Anything else you'd like to tell me before I sentence you?
No, sir.
100 fines, 125 costs, 75 victims' rights, $50 justice assessment, 350 or 60 days. Could have been a lot worse. Do you have the money to pay this?
Yes, sir.
Okay, go down the hall and take care of it, and you're all set. Good luck. Jamie Antonio Williams Bay, 23W31736. Is that you, ma'am?
On Zoom, Judge.
Hello? Hello?
We're not there yet, sir. Just give me 1 second. Ms. Williams Bay, you got to show up on here, ma'am.
I'm right here, sir.
I need your name and I need you to turn the light on, please.
Sir, yes, sir.
She had a lawyer.
Gang?
She had a lawyer on September the 8th or April the 21st.
I'm sorry.
Did I tell her that you could be here by Zoom?
No, Judge, I will tell you that we received a call yesterday stating that the ride fell through. So I told them to try to get a ride. And if not, to zoom in and then speak with you to see if you would want to reschedule or what
Yeah,
you
I'm
would
gonna-
like to do.
Yeah, I'm gonna have to get you to, I'm gonna reschedule this, okay, ma'am? And
Yes,
we're gonna
ma'am.
have to, we're gonna have to make sure that we give her a lawyer. So I'll reschedule it. You want to go out a couple weeks, Heather?
Yes, our next date, 2 weeks out is June 10th. We could do 8:45.
What day of the week is that? Wednesday?
Wednesday, yes.
Okay.
All right, that's what I'll do. Defendant to appear in person. Make sure we have defendant and a lawyer then, okay?
Yes, sir.
Okay,
All right, so you're gonna have to be here, Ms. Williams Bay. You understand that?
Yes, sir. And I will make sure I do can. And if anything do fall through, I will get paid and I can get a lift up there. So I
Okay,
just did
slow down,
today.
slow
Yeah, I
down.
just get paid Friday and I got
Slow down, slow down. I didn't understand what you were saying. We went awful quick.
I was saying like I'm gonna just make sure I got a lift. I'm not even about to make sure I got another person to give me a ride because people keep not showing up. So a lift gonna show up. So I'm gonna just make sure it's scheduled and reserved for next week on Wednesday.
It's 2 weeks from today, June 10th,
Okay.
okay?
Yes, sir.
Did you do the positive strategies program?
Yes, sir. I paid for it, and when I went to I went in there with my screen was broke.
I shouldn't really be talking to you about this. All I can tell you is I told you to attend the positive strategies program, bring proof, defense attorney, bring proof, defendant, attorney. See, I can't read my own writing sometimes, Heather. Something program at Oakland Community.
Yes. I got my transcript if you need that. Like I can have it emailed or anything like that.
Can you take care of your, and then I said, the court will consider not. Geez, Heather. Do you have any other notes on this?
I'm looking, Judge. I do not, because from when I scheduled it, it was a warrant cancellation. And prior to that, it looks like it was 2024. There was a letter to you. It goes way, and then it goes back to 23 when she actually was sentenced.
Okay. Okay, so I'm gonna need you to appear here in person.
Yes,
And
sir.
you bring proof that you took care of whatever it is. I'm gonna have to go back and listen to the tape. Will you do that for me? And just make some notes?
Yeah.
Okay, that's what we'll do. So you have to be here June the 10th, okay, young lady?
Yes, sir.
June the 10th, and just do whatever it is that I told you to do. June the 10th at 8:45, all right?
Yes, sir. I got it.
Thank you.
Thank you.
All right, Dwayne Allen Vaughn.
Yes.
180-128-136. All right. All right. Heather, I don't know if I have an order setting aside the convictions here.
Let me check with Lisa and see if she recalls, because she does all the paperwork for those.
Right. I'm so sorry, Mr. Vaughn. I promise you I'm not gonna take long. My apologies. I just need to get the order. You did have, correct me if I'm wrong, you did have, send this to the Attorney General's office and the prosecutor, right?
I did.
Okay. Let me get that for you if I will, just bear with me, okay? I'm just gonna need to get an order down here so I can fill it out while we're talking. Michael Lasky, Michael Joseph Lasky, 16W809-989. Good morning, Mr. Williams.
Morning, Judge. How are you?
Good, how are you?
Good.
Good.
Steve Williams appearing on behalf of Mr. Lasky. Today's the time and date set for arraignment pre-trial.
Sir, your name?
Michael Lasky.
Where's he been?
Judge, he's been on a journey, but a good journey. And I can get into that on the record, but
All right, so right now, we're gonna take his plea to allowing the licensed driver to drive, and the suspend, revoke, denied will be dismissed. True?
that's correct, Judge.
Is that what you want to do, sir?
Yes.
If you plead guilty here to this, possible penalties are up to $500, fines, 90 days jail, costs, or all those. Do you understand that?
Yes.
And did you sign, read, and understand an advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
All right, to the charge, allowing unlicensed driver to drive, how do you plead?
Guilty.
Were you in control of a 2011 Ford that was being operated on the Meyer Service Drive near Discount Tire in Woodhaven on August 31 of 16 at 3:04 p.m.?
Yes.
And at that time, you weren't driving the vehicle? Yes?
Yes.
You were driving the vehicle, correct? And were you suspended, revoked, or denied?
Yes.
Which?
Suspended.
And are you on probation or parole right now?
No.
Anybody force you to plead guilty? All right, I'll accept your plea to allowing an unlicensed driver to drive. The drive while suspended is dismissed. I'm gonna go ahead and sentence him. Tell me, why is he taking 10 years to get it?
Judge, my client is he did look at his record. My client has been battling a drug problem for the better part of the last 10 years.
What kind? What was his drug of choice?
Well, opiates.
Okay, that's not good.
Well, and here's the good news is that he said he's got his license back. He finally went into rehab 2 years ago, went into St. Mary's, did what he had to do. He's on a very low dose of Suboxone. He's an addiction specialist. He's finally getting things together. He's a journeyman electrician. He's working with the Henry Ford Hospital on that. And Judge, actually, he contacted me, I want to say about 18 months ago about an expungement of a felony. And I said, well, let's run your record. And I said, we got to take care of this Woodhaven matter. And before we think about doing anything, and then obviously we kept in touch, and then from a financial standpoint, we was ready to move forward. Good news is, Judge, this warrant's been out for a long time.
10 years.
Exactly. Great news is, it can't get picked up by anything else. And even though you were waiting and this court was waiting, your staff was waiting, you wasn't out doing and being involved in the habits that got him here in the first place. And as a matter of fact, it would, because of this generous plea offer from the prosecutor, this will not prevent him from moving forward with the set aside conviction of the one felony on the record in Detroit.
Hey, Lisa, give me 1 second. I'm gonna need, he's got 2 charges here. He's got, so I'm gonna need one of that.
That's what this one is, I think. 3, 6.
He's got 2 cases.
Oh, I only saw one on the docket. Okay.
This is only the drug.
Yes. Yeah. Okay.
Okay, my.
Judge, I'm an expert on those. If you need any clarification, I know exactly what's going on up there. I do these all the time. Having said that, Judge, this is what we want. And now with this situation, we're going to be able to move forward with these one more with Frank Murphy, rather CBC, and felony. He took the long route. He inconvenienced his court for a couple no-shows, but he's got a great foundation
Good.
forward. That's what we want, right?
Right. Anything you'd like to say, Mr. Williams? No, sir. I wish you well. 100 fines, 250 costs, 75 victims' rights, $50 justice assessment, 475 or 90 days. Okay, you're all set. Have a good day. Good luck. You stick with it, sir. Don't be tempted, okay? Thanks.
Appreciate it.
Thank you. Good to see you, Mr. Williams.
You too.
All right, now I'm going to take care of you, Mr. Vaughn. Dwayne Allen Vaughn, 18B128136. All right, Mr. Vaughn, my apologies. Your name?
Wayne Vaughn.
I just need to cover some things with you, okay, and verify this, all right? You have not been convicted, so you realize, I don't know if this other case is going in front of Judge Hessen or not. You realize I'm only dealing with the possession marijuana case, correct?
Yeah, I just realized that. Yeah, I did have 2 of them, but okay. Yeah, I'll
Is that
have to
other
look
one
into another court.
Is that other one
I
assigned to
think-
Judge Hessen, Heather?
I'm only seeing the one open
He's got
for
another
us.
one. He's got
Do you have
2
the
different
case number?
He's got 2 different case numbers here. I'm dealing only with the 18B128136. I don't think the other one must have been assigned to me. That's 18B128144A.
Let me take a look at that one.
Do you have any criminal charges?
Nothing.
Go ahead.
Yeah, I'm sorry, Judge. Nothing's even been assigned, date's not even been assigned on that one. The last thing is back in February, certified copy was requested on that, so.
He did attach it to the same application. He's got the case number on there anyway.
Okay,
So it
let me
must-
check with
It
Lisa.
must be Judge Hessen's or something, or else I think they would have given it to me.
Yeah, I'm gonna check in to see if they realize that.
Okay, you've never been convicted of more than 3 felonies, correct?
No, sir.
Let me ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings be the whole true self you got.
Yes, I do.
Okay. You don't have any criminal charges pending?
No, everything is old that I'm having expunged. I have court dates in Detroit and Taylor as well coming up.
But I'm just saying you don't have any charges pending. Those were already adjudicated.
Yeah, no charges pending.
All right. All right. What are you doing now?
I'm 3.5 years sober now, and I work for the union now, local 687. I own business as well, construction company, and we're just moving forward and trying to put life back together.
All right. I'm setting aside the conviction on this. And I'm going to go ahead and grant your applications. So this one, I'm setting aside this conviction and you're gonna have to, did you see anything on who that's assigned to, that 18B128?
We're gonna have to look at it when it comes down here, Judge.
So Mr. Vaughn, why don't you get Mr. Vaughn's number, chat with him? I'm signing this on the Brownstown case, 18B128136, and you guys follow up with the other. Okay, it's the Attorney General's office
Okay.
did respond, and they're saying, hey, they're not really eligible to set aside that conviction, but she's setting it aside because the prosecutor is, because it's marijuana. Marijuana is now legal. So I'm gonna go ahead and take care of that. All right?
All right.
Thank you, sir. Best of luck, but don't leave until you talk to her, okay?
I did send him a message. If you could just respond to that, Mr. Vaughn, please.
Stacy Sherman.
Alrighty, friends, let's move along. Let's go down to Florida. Wade Mercer apparently is still on vacation, hopefully fishing legally and not getting a Class 1 felony or anything like that. But it is Judge Kevin Grover this morning.
First appearance for Calhoun County, May 27, 2026. I'm Judge Grover. We'll begin with State v. Joseph Phillips.
Mr. Phillips?
Mr. Phillips, did you see the video advising you of your rights?
Yes, sir.
Okay, you are charged with possession of marijuana less than 20 grams. You also have a warrant out of Leon County. The warrant out of Leon County has a $500 preset. If you do make that bond and if you are released, if you do not have a notice for a court date in Leon, contact the clerk's office in Leon County and they will provide notice of that court date. Also, there is a preset on the possession of marijuana less than 20 grams of $5,000. Anything from the attorneys regarding the bond?
No, Your Honor.
We just request he be subject to random UAs.
Sure. And Mr. Phillips, you are subject to a random urinalysis. And once again, the bond on the possession of marijuana less than 20 grams is $5,000. And on the warrant out of Leon County, there is a preset of $500 on that bond. You will receive paper notice of your court date in Jackson. Show up on that date and time. If you do not receive, if you do not post the bond, you'll be transported to the court date. And did you see the video advising you of your rights regarding this matter today, Mr. Phillips?
Yes, sir, I did.
Okay. Anything else regarding this case?
As far as the UA goes, hey, whenever I get out, if I go and get my medical card, can I still smoke marijuana?
You know, speak to the person who does the UA, but whatever you're legally allowed to do, you can legally do.
Okay.
Answer to your question. Okay.
All right, thank you.
Okay. Next we have is it Mr. Biller?
Yes, sir.
Odie Biller. Mr. Biller, did you see the video advising you of your rights?
Yes, Your Honor, he did. He's hard of hearing. He's close to death, but.
Thank you. Thank you. Will you advise him he does have a hold for a warrant out of Franklin County?
I've already advised him and he understands that he's going to get transported there, Your Honor.
Thank you, sir. I appreciate it.
All right. Trent.
And this is State v. Trent Smith. Mr. Smith, did you see the video advising you of your rights?
Yes, sir.
Okay, you are here for a number of charges, one being violation of state probation. There's also 3 counts of failure to register internet identifiers. There is a possession of sexual material, including animals. There are 10 counts of possession of child pornography. There's also transmitting child pornography, unlawful use of a two-way communication device, as well as a charge for escape. Anything from the attorneys?
No, Your Honor.
Your Honor, I have been informed by state probation that a affidavit and warrant are in the queue for the signing judge to basically enact. So a VOP warrant should be coming in. As for his new law charges, we believe that this may fit the enhancement under 775.08473B. So there may be a chance that his new law charges qualify for first-degree felonies. We just ask that his bond reflect that.
Very well. And unless there's an objection, I'm intending to move forward with a hold without on the VOP. I think there's enough information in the affidavit to move forward accordingly. So, Mr. Smith, on the violation of your state probation, I am going to hold you without bond. On the failure to register internet identifiers, there are 3 counts. I am setting bonds at $10,000 per count for a total of $30,000 on those charges. On the possession of sexual materials involving animals, I'm going to set the bond in that case at $20,000. I'm going to set that at $10,000. And then also the possession of child pornography, 10 counts, $10,000 per count for a total of $100,000. The transmitting child pornography at $20,000. The unlawful use of a two-way communication device at $5,000. And then the escape charge at $20,000. So if my math is correct, that is a bond on the new charges of $185,000. However, you are held without bond on your violation of state probation. And you cannot have any contact with any minors. You will receive paper notice of your court date, and you will be transported to that court date. Do you understand?
Yes, sir.
And next we have Tevin Bellamy. Mr. Bellamy, did you see the video advising you of your rights?
So,
the paperwork indicates you are both on a violation of probation and a violation of community control. Does that appear to be correct for the attorneys?
Yes, Your Honor.
Okay. And on both of those matters, you are going to be held without bond. You also have a failure to register your internet identifiers, 4 counts. I'm going to set bond on that at $10,000 per count for a total of $40,000. You will be transported to your court date. You will receive notice of that. You cannot have contact with any minors. Do you understand? Next, we have Amber Maldonado. Ms. Maldonado, did you see the video advising you of your rights?
Yes, Your Honor.
You are here on a violation of your county probation. At this time, you are held without bond. You will receive paper notice of your court date, and you will be transported to your court date. Do you understand?
Yes, sir. Oh, yes, Your Honor.
Next, we have Jennifer Vendry.
Rodri?
Ms. Vendry, did you see the video advising you of your rights?
Yes, Your Honor.
You are charged with battery on a person 65 years of age or older and robbery by sudden snatching. Anything from the attorneys?
no, Your Honor.
No, Your Honor.
Ms. Vendry, where do you live?
I'm sorry?
Where do you live?
Where do you live?
Alfred, Florida.
Okay. And how long have you lived in the area?
Probably about 6 years.
Okay. If I'm going to set a bond that you probably can make, if you make the bond, for the time being, can you stay away from Kenneth Perchinsky?
I actually lived at that residence.
Can you stay away from him, not live there?
Yes, I mean,
You say no contact. So
I live on the property, just,
you
I
say no contact.
I live on the property, but just not in the home.
You're not gonna live on the property. You got somewhere else to go.
I'll find somewhere to go.
He's asking, okay.
Yes, sir, I'll find somewhere to go.
Okay, so on the battery, on the person 65 years of age or older, I'm going to set your bond at $2,500. On the robbery by sudden snatching, and by the affidavit indicated that was regarding a cell phone that I believe was ultimately returned. I'll set that bond at $2,500 for a total bond of $5,000. And I will point out that you do have a minimal criminal history. $5,000, if you make the bond, show up for your court date, you will receive paper notice with date and time. And for the time being, no contact with Kenneth Perchinsky. Contact is viewed broadly. No email, no third party, no personal contact. You can't post on social media regarding him or post something you expect him to see. You can't wave at him if you pass him on the highway. Whatever you can think of that may be construed as contact will be construed as contact. If you have personal effects at that location, you have a couple of options. You can request a law enforcement officer accompany you to retrieve your personal effects, and that would be permissible for that purpose only. Or you could have a third party go request your personal effects, but they couldn't relay any information to the alleged victim other than that information that is necessary to obtain your personal effects. Do you understand?
I understand.
You'll receive paper notice of your court date, and you need to show up on that date and time. If you do not make the bond, you'll be transported to the court date. Next, we have I think it was indicated to me there may be a Daryl Buggs that needs to sign a waiver.
Ma'am? Yes, Your Honor. Sign right.
Any questions, Mr. Buggs?
Can I get a copy of both of these waivers? Yes. Any questions?
I just asked him a question.
Any questions for the judge? Or?
Okay, good luck to you, sir. And I believe that concludes first appearance for Jackson County today.
Okie dokie, friends. Once again, good morning. TCF Live, episode 298 today. So Austin had a question in the chat wondering what, how was it phrased? The internet identifiers, what was that all about? So I looked that up. Under Florida law, a failure to ID regarding internet identifiers specifically applies to registered sex offenders and predators. An internet identifier is defined as any designation, screen name, username, or moniker used for self-identification on commercial social networking websites or applications that facilitate commercial or social communication. It does not include PINs, passwords, or social security numbers. Offenders are legally obligated to report any new or changed electronic mail addresses and internet identifiers along with their corresponding website homepage or application software name within 48 hours. Update must be filed through the Florida Department of Law Enforcement Cyber Communications System or in person at the local sheriff's office. So that's what that was all about. And just a parade of fine people in front of Judge Grover this morning. As if children weren't enough, the one guy had to involve animals as well. Shake my head. Okie dokie. Let's go back up to Michigan. We'll check in with Judge DeSanto.
Appearing on behalf of which my client appears to my right and runner, this date time set for the sir, please for the record.
Colin Jones.
All right, good morning, and council, yes, today is the date scheduled for the arraignment pretrial in this matter. This was originally scheduled for April. Oh no, he's originally in custody. Okay, never mind, he bought it out. All right, and so council adds to the arraignment.
As for rating, Your Honor, I've explained today the nature of the charges. My client understands them, so today we wait for a rating, stand mute, ask for a plea of not guilty to be entered for arraignment purposes.
All right, the court will waive the formal reading, enter plea of not guilty for purposes of the arraignment, and then as to the pretrial, counsel.
As to pretrial, Your Honor, my client has been constitutional rights. He is freely and voluntarily entering a plea of guilty as charged. This is destruction of property, and then we're going to address the issue of restitution at the sentencing, and ask the prosecutor to bring in the complaining witness because we've got some questions about some of the restitution numbers.
Okay. All right, sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes.
All right, and you heard the plea that was placed on the record, correct?
Correct.
As to the charge of malicious destruction of property, sir, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand that by entering into a plea, that you'll be waiving some of those rights.
Yes.
You understand as well, sir, the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes, sir.
Your Honor, in addition, I forgot to mention, we're asking the court, if the court accepts the plea, to take it through to MCL 771.1. I've explained to my client what that means, the basically plea under advice.
All right. And sir, as your attorney just stated, you do understand what the 771.1 status is.
Yes, sir.
Knowing all of that, do you want to continue with your plea?
Yes, I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please order your client.
Mr. Jenkins, on or about March 22nd, 2026, in the early evening, about 8:30, were you in My Place Lounge in the city of Wyandotte?
Yes.
You were with another gentleman, correct?
Correct.
There came a time where you had a little bit of a disagreement between yourself and some of the wait staff. Is that correct?
Correct.
And also you had been drinking alcoholic beverages that evening, correct?
Correct.
There came a time then you pretty much, you and your friend decided you had enough of the place and decided to leave, correct?
Correct.
Before you left, you took a bar stool and broke it, is that right?
Correct.
And also you grabbed a strand of lights and pulled those down and some of those got damaged. Is that correct?
Correct.
You did that intentionally, right? No one gave you permission to do that.
Yes, I did.
So I'm sorry, hold on. That was a double-ended question. So,
Oh, okay, I'm sorry. No one gave you permission to do that to the property, did they?
No.
All right, that's fine.
all right, thank you. And it appears as though what the damage appears to be, based upon the police report, were 2 metal high back bar stools with padded seats, 1 electric power cord for an LED string of lights. So that appears to be what the restitution will center upon, correct?
Well, that's what we're pleading to. But if the court looks further, I don't know if it was the owner of the bar or not, submitted a very large bill with floor damage and some other things that I don't believe my client had anything to do with. But we'll find that out at the restitution hearing, I would imagine.
And sir, where did you play professional football?
The Packers, the Eagles, the Giants, and Washington.
What position did you play, sir?
Defensive end and defensive tackle.
And how long have you not been playing football?
About 8 years now.
You played 13 years, is that correct?
Correct.
Is there also a charge of operating while intoxicated, counsel?
That's for the driver that was with it.
Oh, that's right. Okay.
I think that's been resolved, the prosecutor said, but I'm not sure.
Okay.
And I represent him.
Or
My plan is,
5 bar stools?
yeah, I can't figure that out either, Your Honor. I mean, if necessary, there's a video,
Okay.
but you know, if the court needs me to get the video discovery there, I'll do that.
Well, the video may be helpful for restitution purposes, for
I'll
sure.
get it. Yes.
All right, sir. And are you retired or are you working?
Yeah, I'm retired. I work in the schools. I used to work at Adams Middle School, the White Bus Line.
Okay, and what do you do there, sir?
I'm a building substitute.
You're what?
A building substitute teacher.
Oh, building substitute. Okay. Have you ever failed to appear in court for any reason, sir?
No.
Are you out on bond in any other jurisdiction?
No.
Did post a $500 bond in this matter.
Well, I will also state, if I did not, that the court does find the plea is knowing, voluntary, and factually accurate. The court will accept your plea, determine your eligibility under 771.1 at sentencing, which appears to be something that would be applicable as you don't have any prior criminal history.
Your Honor, I'm going to ask the prosecutor for discovery order then for the court to sign. I don't have it with me.
Okay,
All right, thank you.
that's fine. Okay, the court's going to continue your cash bond. You're not to return to My Place Bar. You are not to have any contact with My Place Bar staff, and you're not to possess or consume any alcohol or drugs unless prescribed. All right. Do you, sir, if you were to test right now, what would be detected in your system?
Other than prescribed medications.
Maybe some marijuana
All right. When's the last time you used it, sir?
last night.
Okay. Are you still under the influence?
No.
Okay. That's what I wanted to confirm, sir.
No, I just petting stuff sometimes.
All right.
Your Honor, I did want to address one matter. If he's not sentenced beforehand, in July, he has a pre-planned trip for work. He has to leave the state to go to which state? Milwaukee, Wisconsin?
Wisconsin is.
That's for work?
Yes, I do some appearances and different things out there.
Okay. Oh, so for, no, okay, not for your building substitute work, but for your own private business purposes. All right.
So we're asking for permission if it takes that long. Do you have that date, sir?
Yes, I believe it's July 18th.
All right, we verify that with the probation department when we speak to them.
Yes, that's fine. And if for some reason we have not had the sentencing yet, just submit something into the court with your dates of travel. And that shouldn't be a problem.
Okay.
Okay. All right. Thank you.
Should you go to probation then?
Yes, thank you.
All right, I'll show you where it is. Thank you.
All right, thank you. Have a good day. You'll get a copy of your bond conditions there as well, sir.
Have a seat.
No. He'll get the.
All right, friends, let's change it up. I want to head down to Kentucky. Judge David Williams. To be honest, I'm not sure what we're stumbling into, other than when I was scanning feeds, I heard him say words to the effect of, "We don't get a lot of murders around here." So let's see what that's all about.
Make room for him there. Are you Dylan Cherry?
Yeah.
Good morning. We're here on 26 CR 0013. Mr. Cherry, were you born in 1991?
Yes, sir.
What is the last? We're here on a pretrial conference. What's the Commonwealth have to say?
Judge, I'm not really familiar with this case, other than I understand there's some issue with the bond. Is that correct?
Well, Mr. Cherry did want to hear on bond, but there's, with this type of charge, DCBS has been involved not only with the events charged, but also in the past. And we talked with Mr. Stalking about doing a reorder to get some DCBS records, which we should be getting to the court very soon. And there's actually some out-of-state records that we may be looking to get. What kind of time frame are you talking about for discovery to be completed? Well, with DCBS records, they have to do a review on their end. Just tell me the time period. I'd say a few months at least. Okay, what's his bond? I believe his bond is currently $25,000 cash. He can make a $5,000 bond if the court were willing to consider a $50,000, 10%. What's the Commonwealth's position?
Judge, my instructions are specific. If we don't come to an understanding on the bond today, then let us have to schedule a bond hearing.
Okay, well, let's schedule. What are the total charges the Commonwealth seeks to advance in this case?
And multiple counts of criminal abuse is first degree. Assault in second degree. Wanton endangerment in first degree.
Well, we're gonna have to have a bond hearing on this thing. So Commonwealth has to have a position and you can't negotiate. So let's schedule a bond hearing on June the 25th, okay?
June 25th, thank you, Judge.
June 25th. Commonwealth versus James Flowers. James Flowers.
He's not got that there yet. He's still downstairs. He's in district. He's in district.
I'll go down and get it.
No.
Go down and get it. Commonwealth versus Thomas O'Donnell. Commonwealth versus Thomas O'Donnell, excuse me, 22 CR 00103. Are you Thomas O'Donnell?
Yes, sir.
You born in 1961?
Ma'am.
The last 4 and 3.
Yeah.
We have an ex parte motion that will be heard later. Is that correct?
Yes, Judge.
And then there is a motion to release property. Is the vehicle? To come to Commonwealth moves the court to enter an order releasing I'm fixing to tell you what it is here. 2017 Ram Dually truck and gives a serial number to Paul Wilhelm. Now, who is Paul Wilhelm? Is this the victim's truck that we're talking
I
about?
understand there's an order.
Okay, I will sign the order. I just want to make sure Paul Wilhelm is an heir or is that correct? Is that correct?
Yeah.
So the Commonwealth has agreed to release the truck to Paul Wilhelm. Is that correct? I'll enter the order. Next matter has to do with sentencing. Mr. O'Donnell, have you had an opportunity to review the pre-sentence investigation report done by probation and parole?
I have.
Is it substantially correct?
Yes.
Okay, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
You have any statement to make?
No, Your Honor.
Okay. Mr. O'Donnell, you were tried by a jury here in Cumberland County. Had a lengthy trial. You were afforded every opportunity and a valid defense, expert witnesses, that sort of thing. The jury found you guilty of murder and sentenced you to life. I've carefully reviewed this case. I've read all of the statements, reviewed all of the information that was there. I was particularly touched by the victims' statements, the relatives. The deceased victim's mother made a very poignant statement. I don't know whether, I assume that she's still alive. She had very serious kidney cancer and lost her son, lost a caretaker, had to suffer through 2 years or so since you committed this crime. With the doubt she expressed, as the daughter did and the son who testified in this case, what effect your terrible, horrendous actions had on that family. Your actions have had a terrible impact on this community. This community is not a violent community. We have very few murders that are committed here. You never stepped up and accepted responsibility for your actions. And I looked at you very carefully, even when there was description of the state of the victim's body, how he was decomposed, how after you left him over there, having shot him twice in the head and twice in the body, his body decomposed. The autopsy, when they were opened, I won't even go into the details, but the autopsy would be something that these jurors or anyone who saw this case and this family could never get out of their mind. And then I look at your record, a very sparse record of any criminal activity, and I wonder how you got in this situation. You spent days at this trial with your very able counsel trying to discredit witnesses who were going to locate the 2 cell phones here that they could track from California to Texas to here over to the scene. They gave evidence how you stayed in a hotel down in Cookville and looked at the exact address where this murder was. Your DNA was found in the vehicle. And after all this sort of thing toward the end, you tried to create a situation, well, you were there. I don't know why you wasted everybody's time and effort going through all this for challenges forensic evidence when you're going to, your folks were going to say that. And I will tell you something else, counsel. You know, I've thought long and hard about your closing argument in this case, where you put forth your theory of the case without any evidence whatsoever. So in existence, out of whole cloth. So this, I practiced law for 45 years. This is one of the most cold-blooded, heinous acts that I've ever seen anybody committed. I don't know how, with the background I saw from you, you got your mind to do this. I'll never understand how you could, you know, come up with this plot, use the burner phones to make the appointments, go over there and call a guy that's just trying to make a living, call him over there thinking he was going to get a job and just cold-heartedly murder him and leave him there to decompose. So maybe you'll have time to accept your actions while you're there, but I'm going to sentence you to life in prison. And I'll just tell you that I think that that is most deserved. And if this had been a death penalty case, you know, I wouldn't have been surprised whatsoever that you would have been sentenced to death in the electric chair. So you're in the custody of the Department of Correction to serve the rest of your natural life in the penitentiary. Thank you. Take him out of here.
Your Honor, I do have an order to allow him to proceed in former populace on his appeal effective.
Submit it.
Can I approach with it?
We'll give it to the bailiff. You can take him out. I'd like to speak to the attorneys up here for a second. Mr. Hunley, will you come up here? I have great concern.
Dag nabbit, I was hoping he would leave his mic hot there. The fact that he was aggravated, obviously, and for good reason, but what caught me at the very end, and I don't know if you caught this, is that the attorney wanted to approach with a document, and the judge is like, no, give it to my bailiff. So he wasn't even happy with the attorneys on this one. Anywho, now I know what was going on when I paged through and he was talking about how we don't get many murders. Now we know. We might come back to him later, but in the meantime, let's go back to Lake County, Ohio. New contestant for Judge O'Donnell.
Johnson.
Thank you, Your Honor. We are here in the matter of the State of Ohio versus Jeremy Williams, case number 26 CR 000369. The defendant is present with his attorney, Ms. Novotny. We're set today for an information. The state filed a 1-count information, failure to comply with an order of signal of a police officer, a felony in the 4th degree. It's the state's understanding that the defendant will plead guilty to that today.
All right. Ms. Novotny?
Yes, Your Honor, that is correct. Ultimately, before coming into court today, Mr. Williams and I went over the waiver of indictment as well as the written plea of guilty forms. He is aware of what this proceeding will entail and would like to enter a plea of guilty to the charge.
All right, thank you. Mr. Williams, how old are you?
21.
How far did you go through school?
All the way until graduation.
Are you a U.S. citizen? Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
Yes.
What have you taken?
Marijuana.
And when did you do that?
Yesterday.
Why did you do that?
Just doing it.
Huh?
Just doing it.
Gotta stop doing it.
Okay.
Does it affect your ability to understand what's going on here today?
No, sir.
Did you get a copy of the information filed in this case?
Yes.
Any questions about it?
No.
You understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict you?
Yes.
Did you discuss that right with your attorney?
Yes.
And are you going to waive that right?
Yes.
Your Honor, in open court, myself and my client signed the waiver of indictment and passed it to the prosecutor and the witness the same.
Your Honor, I also witnessed the defendant sign the waiver of indictment. I have signed it, and with your permission, would return it to the bench.
And I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, stop me. If you want to talk to Ms. Novotny some more, let me know, and I'll give you more time. You understand that?
Okay.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to this charge?
Yes.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes.
This charge of failure to comply is a felony of the 4th degree. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes.
Do you understand that this guilty plea will result in a driver's license suspension of at least 3 years up to your lifetime?
Yes.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control?
Yes.
Is it a 2-year discretionary? Or is it a 1 to 3?
2-year term.
You might have to serve a period of post-release control for up to 2 years under the direction of the parole authority.
Yes.
If you are placed on post-release control and violate any conditions, the parole authority can send you back to prison for up to 9 months. Do you understand that?
Yes.
If that violation of post-release control is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
Yes.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I would sentence you to in this case?
No.
Do you understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer? Yes?
Yes.
Have you had enough time to talk to Ms. Novotny before pleading guilty today?
Yes.
Has she discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice she has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
Yes.
Have you been threatened or coerced?
Oh, no, my fault.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No.
Ms. Johnson, if the case went to trial, what would the evidence show?
Your Honor, had this matter proceeded to trial, the state would have shown that on or about the 11th day of March in Lake County, Ohio, the defendant did operate a vehicle so as to willfully elude and flee Willoughby Hills police officers after receiving both visible and audible signals to stop the vehicle. The pursuit lasted approximately 6 miles, beginning on Interstate Route 90 and continuing on to Interstate Route 271, reaching speeds of up to approximately 120 miles an hour. The pursuit ended when the defendant voluntarily pulled the vehicle over. Thank you.
Thank you. Ms. Novotny, anything to add to those facts?
Just, Your Honor, once he was voluntarily pulled over, he was cooperative with officers.
All right, Mr. Williams, did you hear what Ms. Johnson said, that the facts would show if the case went to a trial?
Yes.
Are those facts true?
Yes.
What is your plea to failure to comply with the order or signal of a police officer, a felony for?
Guilty.
Ms. Novotny?
Today is 5/27/26.
Your Honor, in open court, myself and my client signed the waiver or written plea of guilty form, and it passed it to the prosecutor to witness the same.
And I also witnessed the defendant sign the written plea of guilty. I have also signed it. With your permission, I'll return it to the bench.
Mr. Williams, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes.
I'll accept the written plea of guilty. Defendant was present. Ms. Novotny advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. I will accept the plea of guilty and find him guilty of failure to comply, a felony 4. I'll refer this for a pre-sentence report and a drug and alcohol evaluation. Sentencing will be July 1 at 2 p.m. Ms. Novotny?
Yes, Your Honor. At this time, we would like the court to consider a bond modification to remove the GPS monitor off of Mr. Williams. Ever since he's had it on since Willoughby, he has been very cooperative with it. Ultimately, he's been following all the bond conditions that was set of him with no driving.
Well, almost all of them.
Almost. You're right, Your Honor. With no driving specifically. He's 21 years old, Your Honor. He graduated high school. He does have a job at Speedway. He is indigent and requires the help of the public defender. Once the case comes over to from Willoughby Municipal Court to the Common Pleas Court, it's client funded at that point, and I know funds are short for Mr. Williams with that respect, and we would ask the court to see if they would be able to consider removing the GPS monitor.
Ms. Johnson?
The state would largely defer to the court as to the GPS monitor. I will just note the obvious concern is that he has fled and eluded from police before, so I think it is useful to have the GPS monitor on.
All right, I'm going to remove the GPS monitor as a condition of bond, but you, did you know it's a violation of your bond to smoke pot?
Yes, sir.
Okay, so you're doing it, why? Knock it off.
Just,
Because if you do it again, you're going to sit in jail until you get sentenced.
okay.
Anything else, Ms. Johnson?
No, thank you, Your Honor.
Novotny?
No, thank you, Your Honor.
All right.
It's TCF Live, my friends. Half the show in the books already. Time flies. Let's go back up to Michigan, check in with Judge DeSanto, new contestant there.
All right. So let's go on the record in the matter of Danielle Butler, 24720.
Your Honor, good morning. Richard P. Serrano, P. 33828. Today, Your Honor, I appear as MIDC counsel. For the purpose of the show cause on behalf of Ms. Butler appears to my right. And ma'am, please state your name for the record.
All right. And so good morning. Today is the date scheduled for the show cause. You previously had pled guilty to the show cause November 5th of 2025 on the $1,298.40 balance. You are going to pay $25 per month beginning December 1st. It appears as though you made 2 months of payments because your balance is now $1,241.40, but you must have stopped making payments because you're back here in court.
That's correct, Your Honor. She's not employed. She lives with her mother, single. She's not on probation parole. Spending, she's looking for work. She's going to plead guilty to the show cause and wants to get back on a regular payment program of $20 a month.
Well, hold on a minute. Hold on.
Okay.
Ma'am, why are you not working?
Because I don't have a job.
Yes, I understand you don't have a job. Why do you not have a job? I should have clarified my question.
I'm not sure why I don't have a job. I mean, I haven't been getting any replies. I've been going to temp agencies. No temp agencies have any job openings. Or they just require too much experience that I don't have. And they don't train for the experience.
Okay, and how old are you?
25.
And where have you worked?
I worked at warehouses. I worked at houses. That's really it.
Okay. So how are you supporting yourself if you're not working?
I gotta do what I gotta do.
She lives with her mother. She helps out.
What does I do what I gotta do mean? What does it, I mean,
Sometimes I ask, but I don't have no job, so I don't
so what do you do all day?
do all that.
Right, are you,
I'm unemployed, so it's not much to do all that. I'm confused on your question, ma'am.
well, how many places are you applying to every day?
Maybe 10 more.
10 a day?
Correct. I can show you the proof.
And so how long have you been doing that?
Since September.
So it's 10 a day since September.
Yes.
And you don't have any options for work?
Nobody's replying back. And my phone is broken, so I can't really receive calls or text messages like that.
Okay. Well, so ma'am, do you have a car?
No. Somebody told me that's the whole predicament I'm in.
And so, do you have a valid license?
Yes.
So do you have a card that could you drop your mom off at work and then you could maybe DoorDash or Uber or something to give you some type of income? Instacart shopper?
I can't do that with my mom's car now. I've asked her, I can't. It's really not many ways that I get money. That's why I pay what I can. That's why I asked to do $20 a month. instead of 25, because it's still service fees when I pay online.
Well, no, there are, yes. Well, I don't know how, do you have an email account?
Yeah,
Do you have a way to check your email?
yeah.
So are you receiving any email responses?
Barely. I'm gonna say when I do receive email, I respond back to them.
It's very perplexing that you've been submitting 10 job applications at least per day since September and you don't have any employment.
No. Jobs aren't hiring. I'm not the only person. It's been hard to get jobs.
Have you applied at any of the auto companies or any other warehouse jobs? I understand those places are hiring often.
Yeah. Most of them, and when I call fixing agencies, they tell me that they do not have any jobs. I apply on Indeed, Indeed doesn't do much, they don't reply back. It's not really that many job sites to apply on, unless they're just taking your information. But I don't really know.
And if you test today, ma'am, what's in your system? $20 per month. Beginning,
Works better for her.
I'm sorry,
The end of the month works best for her. Is that
beginning
correct?
June 26th. That's the last Friday of the month.
I'm not talking to you, I was going to say something else, because that was my question before.
Yes. Your Honor, she has a question about the fees that are charged. Who did she discuss that with?
The fees,
Yes.
well, the fees that I assessed at sentencing,
You're talking about the fees when you pay?
I guess because when I first got off the probation, my ending, it was 1269, and then what I see still I owe is 1241. And I
right, so
every month.
there would have been late fees added on.
Late fees to what?
To not paying.
I've paid every single month. So that's why I was confused on what late fees.
Okay, so what I would do then, ma'am, is I would go over to probation, ask for a printout of the fines and costs, the assessments, and then what your payments are. That will help give you an idea as to why the balance is what it is, and if there's an error, then we can discuss it and correct it where it needs to be corrected. All right, and then continue submitting 50 job applications per week.
Thank you, Your Honor.
All right, have a good day.
Okie dokie, friends. Before I get off on the rant that I'm about to get off on, Barbara, because I forgot to acknowledge this earlier, and my apologies. Thank you for the $5 super chat. What a happy day. We're getting some great court here today. Thanks, Dan. Best host on YouTube. I appreciate that very much. Thank you, Barbara. So let's do math on this lady. So giving her a whole bunch of benefit of the doubt. Let's say she says she started in September. Let's say that means October 1st. That means there were 238 days that have passed between October 1st and today. Let's give her a further benefit of the doubt and cut that number in half because, you know, weekends and holidays and I'm just not feeling well days and all of that. That leaves 119. Let's multiply that by 10. That means by her number, she has applied to 1,190 jobs and still has not managed to find employment. I don't buy it. Shut the F up. This stuff drives me up a freaking wall because I've spent my life working hard, finding ways to make things work. I've spent the last almost 20 years now self-employed. So I have no safety net, no anything. It is all on me. It's all on my wife. It's all on us. And I hate the excuse of I can't find work. You're not sufficiently motivated. It's just that simple. I'm sorry I'm off on a rant, but this stuff drives me nuts. It's not that she can't find work. It's that she can't find what she wants to do. She wants some cushy thing somewhere that pays her ridiculous amounts of money where she doesn't have to think. That's what it comes down to. Anyways, so yeah, super generous math. If she's to be believed, she's applied to 1,190 jobs. And she still claims that she cannot find work. She deserves everything that she will get, in my humble opinion, allegedly. Okie dokie, let's go to McNally. Go there.
Yeah, on April 29, 26, to operating while visibly impaired. I referred her for a screening and assessment. I got to tell you, more things happen at fast food drive-throughs than anything, you know? But at any rate, so she was referred for a screening and assessment. Have you had the opportunity to review the report with her, and are there any material additions, corrections, or deletions?
Your Honor, I have had the opportunity to thoroughly review this report with my client. There are a couple of revisions that we will request, Your Honor. Number one, my client lives pretty far from here. She's asking that the court consider this reporting remain non-reporting. And she's also asking for community service instead of work program. She's starting a job on their full time. It's going to be pretty tough for her to work that out. That's all she's asking for. We'll consider that. She'd appreciate it.
All right. Then, is there anything that you would like to tell me?
No, sir.
Can you call in Mr. Urick for me real quick?
Yes, sir.
What do you think would concern me here, young lady?
Non-reporting.
No. Guess again. Okay, so you're 18 years old. You cannot leave the bank. You're almost twice the legal limit, and you're driving around in a drive-through back and forth, and people are reporting you. This is a bad sign when you're 18 and you have a 148 on the breathalyzer. Mr. Urick, your name?
William Urick on behalf of the city of Woodhaven, Your Honor.
Did you guys ever enact the cost of recovery ordinance?
I'm sorry, say it again,
The
sir?
cost of recovery ordinance, do you guys have one?
We do.
Okay, I'm just gonna ask you to remind me on these. I'll authorize up to 150 on a breathalyzer, 2.25 on the blood draw, if it's a blood draw, because there's a lot more time. But please write those on the stick form going forward if you
Yes,
would.
sir.
Okay, good enough. That's all I had to say. So I want you to understand that's my concern.
Oh, yes, I completely understand.
And you seem like a really nice girl, and I'm only telling you that when I see people like 18, 19, 20 coming in here on drunk drivings, I don't keep stats back here. I don't have time. But I'm telling you, I hope you're gonna take this seriously, because there's a really good chance you're coming back. I'm only telling you, according to statistics that I have somewhere in the back of my brain here. You can't be out drinking shots. You've been drinking since you were 16, you reported. I appreciate your truthfulness. There's a difference when you start drinking and drive. Especially at that age. That's all I'm gonna say about it. 14 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I want you going to AANA in person at least one time per week until you are in an outpatient treatment program. Once you get in outpatient, you no longer have to attend AA or NA. Every time you go, you have to have the form signed. Have you been going to AA? Like, do you have your proof?
I've seen it, Your Honor. She's been.
Okay, how many times has she gone?
She's gone every week. She was supposed to.
Good. Continue going AA once a week until an outcome. Attend the Victims Impact Panel. Serve 4 days jail credit, 1, serve 3. I can't let you do these by way of community service. $35 a day charge for that, $105. That's probably light. I should probably order more. 300 fines, 200 costs, 75 victims' rights fee, $50 justice assessment, 6 1/4 screening fee, 60 for 685, $40 in attorney fees for 725. You have 150 in cost of recovery, bringing your total to 875 plus probation fees of 280. So your total is 1155 plus the court work program fees of 105. 1260 is your total. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. You may be eligible for early discharge. You get all this done in 7 months, you can make application for early discharge, and by law, you're entitled to it, provided there's been no violations within the preceding 90 days. Again, if you violate, you could get 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. Do you fully understand the sentence, ma'am?
Yeah.
Okay, how much of this can you pay? And the other thing, and I don't want to get on you too much here. Are you working?
I am working on it right now.
Where?
I'll start a new job today.
Where? Okay, how many hours are you gonna work?
30.
Okay, maybe they'll bump you to 40 or better. I don't know why you were terminated from Starbucks, but go ahead.
I was terminated because of the night that August, when I had to go to work in the morning and I could not.
Okay. You seem like a nice young lady. Your grandma shouldn't be financially helping you unless your grandmother is.
Yeah, she will not be financially.
All right, good enough. How much, can she pay anything today or not?
Not today, Your Honor. She's proposing a payment arrangement of about $75 a week starting June the 8th. That's what she gets first.
I'll let her start beginning June the 15th. If you don't have the money at any time, no worries. All the court will go on Zoom, or you can come in here and talk to me, and I'll be more than happy to give you an extension. I don't care how many times we have to do it. All right?
Yep.
Good luck. Thank you. Second. Jasper saying Secon. 267841410. Then next I'm going to take home.
Yes, sir. Yes, sir.
You have to start your video, sir.
Yes, sir. Just give me a minute, sir. Sorry, sir. Sorry for this.
Bottom left-hand corner of the screen, sir.
Yes, sir. Hi, sir.
Okay, hi. Good morning. Your name?
Just Singh Sikho.
I'm going to ask you to take your hat off if you would, please. What brings you here today?
Sir, actually, I got a speeding ticket in Michigan 2-3 months ago.
I know.
want to-
You're supposed to pay all your fines by April 30, and you're logging in here May 27th. Why didn't you pay them, and why are you logging in here now?
Sir, actually, I know I was speeding at that time. I take fully responsibility of my mistake, but sir, I have no prior violations on my CDL, and right now
you have no what?
I'm facing financial hardships right now.
All right, next time, what did I tell you though? I told you to come in and talk to me on or before the due date. So I'm gonna let it go this time, but next time you have to follow that directive, okay?
Sir, actually, my work permit is expiring in a week. I'm going back to my country. I don't have money, sir, to pay the fine. I'm just working part-time right now. And my girlfriend is not working. She's unemployed.
Where are you returning to?
So India.
I'm sorry, say that again?
India. And my work permit is expiring on 5th of June.
I'm having a hard time, no disrespect. I'm having a hard time understanding you. How much can you pay on this at all?
So to be honest, I have nothing. Like, please, like, it's your choice, sir. Just tell me. I can try to pay. If you're gonna forgive me, the full fine is.
When are you going back to your country, to India?
Sir, my work permit is expiring on 5th of June, maybe in June, in mid of June.
Can you pay $75 on this?
Okay, sir. I can pay.
I'll tell you what, you pay $75 and I'll waive the balance. Can you pay it today?
Yeah, sir. I can make it. Yeah.
I'll waive the balance. I don't ever do this, but I will here because you don't have time to do community service and you're leaving, and I believe you, and you seem like a nice kid, and I don't have any doubt that you're not lying to me. Pay 75 today and I'll waive the balance and you're all set. I sincerely wish you well.
Sorry, sir?
I said, I really wish you well. Pay 75 today and I'm waiving your balance.
Okay, thank you so much, sir. Thank you so much.
Have a great day. Good luck to you.
Bye, sir.
Dustin
Thank you so
Lee
much.
Hawk, 267-841-1057. Come on up here, Mr. Hawk, to your name.
Dustin Lee, how?
You're going to plead guilty to.
As the case come back from Mr. Hull.
Okay, he's going to plead guilty to is charged to this anti-blight violation. It's going to be taken under section 771.1, and he's going to take care of this, right? Mr. Hoff, do you understand what has been said here? If you plead guilty under this ordinance section, possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that? You just sign, read, and understand the advice of rights.
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
Can you call in 249 prosecutor to the charge of violation of the anti-blight ordinance? How do you plead?
Yep.
Are you the owner of the property at 26771 Allen Road in the city of Woodhead?
Yeah.
And on January 6th of 26 and continuing through this day, did you violate the anti-blight ordinance?
Yeah.
In what respects?
I have a fencing business, and the things I tear out from people's yard and end up in my backyard, and I don't have time to get every.
Well, you're gonna have to.
Stuff to the dump, and I have been.
What kind of things?
Right now, I have everything on the trailer.
What kind of things?
Old fencing. It's just old fencing. I have a whole trailer ready to go to the dump.
What side of the road is that on?
The east side,
Okay, so you're on the east side by where?
Freedom.
Okay.
I'm right by.
How close is your closest neighbor?
Nobody behind me.
I didn't ask you that. You got neighbors lining up next to you on the left and right, correct?
Yeah.
How far are they from you?
One neighbor which is like 10 feet, and then no neighbor on the other side.
Is the house vacant on the other side?
No, it's
Empty lot?
yeah, it's a old property that's in like foreclosure.
Your name?
William York, I'm half the city, what is it?
Are you on probation or parole?
Judge, he's on probation with Judge Heston.
For what? Well, he better get going. You mean he's on probation for Judge Heston? I'm giving him another 771 and he still hasn't cleaned it up? Is that true?
It's
Hey.
for concrete.
Listen, I don't care what it's for. I'm not taking this under section 771.1. If he's got another one going on over there under 771.1 and he hasn't followed her directive,
Judge, it's not a light issue on the other.
what's it for?
There was, I believe, when there was some road work done, they installed a driveway, is that what it had? Yeah. And he's got a gravel driveway, but they want him to go ahead and make a concrete driveway. And then
He's got another blight case going, right?
that's not blight.
Well, wait a minute.
It's a CFO. It's CFO.
Okay, same type of thing to me. He's not following building officials' directives. What are you doing, Mr. Hunt? I mean, listen to me. Has anybody forced you to plead guilty?
No.
And he's on probation? You understand, was he on probation on January 6th of 26?
When did you get your
No,
probation?
no, I was not. No, they.
Okay, well then that is not a violation of probation then. I'll accept your plea. I will take this under 771.1, but you and I are gonna talk. Let me see the pictures you have there. And you're gonna get this done. And if you don't get it done,
Yes, sir.
we're gonna have a big problem. Now, they issued this citation in January and we're just getting around to May 27th. Jeez.
Just, there's the debris that's on that trailer, which is what needs to be hauled off the property.
I'm
That's
setting this for,
freed up.
I'm setting this for sentencing in a month. And I'm coming out and looking. You don't have a problem with me coming onto your property, do you?
No, sir.
You're gonna have it done in a month.
Yes, sir.
Find some other place to store your junk. Neighbors don't wanna look at this.
When we first got our property's B3 commercial, they said you could put our fencing material behind the garage, which that was our understanding when we moved into the property.
Who's they?
The city.
Who's they from the city?
Building official, I guess,
Do you know who it was?
Tackett, I do believe John Tackett.
Was there a John Tackett in the building department?
I'm not familiar.
How many years ago?
Oh, back in 2020.
I don't remember a John Tackett, but
I believe the inspector that's here, she did verify that that is her boss. I did ask her that question.
where is she?
She's in the jury room.
Get her in here, please. Mr. Opt. I personally, these are not, look,
I can take that trailer to the dock today and move in the car, is no problem.
what is your name, please?
Laura Jensen?
Was Mr. Tackett your boss?
Yeah.
When was he there?
I do not know.
He's telling me that the building official said he was gonna be able to dump old fences back there. Is that not what you told me?
No, not double fence. I could keep my fencing material that is like
Did-
staged for jobs. That's different than like, yeah.
Do you have any reason to believe that Mr. Tackett did or didn't say that?
I would have to believe that he did not.
So would I. That's why I called you in. Mr. Hopt. Do you have this in writing?
No.
I'm giving you a sentence date in a month. I would like us all to meet out there. This is a Wednesday morning, Heather. Let's make sure it's not gonna interfere with sobriety court. I guess I could drive over there after sobriety court and I could be there at 8:15. So if we're doing 4 weeks from now, we can all
That would
come
be-
over there. Any problem with that, Mr. Hopt?
No, sir.
And you guys can take more pictures and monitor the situation, but you're agreeing to clear the property of debris to the satisfaction of the code enforcement officer and acquire a CEO. So why don't we do it out 4 weeks? When is that, Heather?
June 24th.
At 8:15 or at 8:30 will be the sentencing date. Make sure you get that in my book, will you? We're gonna meet out there, me, my court officer, the enforcement officer. If you want to come, Mr. Urick, you're free to. If you want to come, Mr. Gates, you're free to. We'll meet there at 8:10. Would you make sure you remind me of that? So that's what you're gonna do.
Yes, sir.
Has he worked on it at all since this case was pending?
Yes, sir, you can.
To what extent? Give me the percentage of how much he's cleaned up.
I want to say 50%.
Let's get the other 50 done in the next month, then I can go easy. Then we're all happy, right?
Yes, sir.
Good enough. We'll see you out there on June the 24th at 8:10 in the morning. Have a good day. Down the hall, get
June the 24th at 8:10 in the morning. I need some of my Michigan friends to be there with cameras so we can add that to the morning's show. Oh, heavens. Let's Let's go back to Judge O'Donnell, new contestant there.
Carol?
Thank you, Your Honor. Now, if it please the court, we're before the court this morning in the matter of the State of Ohio versus Marquise Thompson, case number 26 CR 514. The defendant is present in the courtroom with his attorney, Mr. Chad Malky. We are before the court for purposes of a change of plea in accordance with the plea agreement that's been reached between the parties. To please the court, have put the terms of the agreement on the record. The defendant, pursuant to the agreement, will withdraw his previously entered plea of not guilty and will plead guilty to count 2. That's an F3 failure to comply. Upon the condition of that guilty plea being forthcoming after findings of guilt, the state would move to dismiss the other counts on the indictment. As to sentencing, the state will review the pre-sentence report prior to making its sentencing recommendation. The defendant can request any sentencing recommendation that is available, that he wants, and that's it, Judge.
Thank you. Mr. Mulkey?
Thank you, Your Honor. All of that is accurate. I conferenced with my client as recent as this morning. He indicated didn't have any questions. I anticipate him going forward with that change of plea as recited by the state, Your Honor, and then when appropriate, we would like to address bond. Thank you.
Thank you. Mr. Thompson, how old are you?
34, sir.
How far did you go through school?
I graduated and I went to Fortis College to gain an HVAC technician certification.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
Yes, just my Lexapro for my depression and my high blood pressure medicine. That's it.
When did you take the Lexapro?
Around like 8, probably 8:30.
This morning or yesterday?
This morning.
Does it affect your ability to understand what's going on here?
No, sir.
All right, did you get a copy of the indictment?
Yes, sir.
It's been represented to me you're going to plead guilty to count 2, failure to comply with the order, signal of a police officer, a felony 3, and then the remaining charges will be dismissed at the time of sentencing. Is that your understanding?
Yes.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, stop me. If you want to talk to Mr. Mulkey some more, let me know, and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any question about any of these rights?
No.
Do you still want to plead guilty to this charge?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, sir.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
In count 2, failure to comply is a felony of the 3rd degree, and that carries with it a maximum prison sentence of 60 months and a maximum fine of $10,000. Do you understand that?
Yes, sir.
Are you currently on post-release control to the parole authority?
No, sir.
Do you understand that your guilty plea in this case will result in a driver's license suspension of at least 3 years up to your lifetime?
Yes, sir.
You understand your felony conviction will prevent you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed in this case, you will have to serve a period of post-release control? Is it 18 months or is it 1?
1 to 3 years.
At least 1 year, up to 3 years, you'd have to serve post-release control under the parole authority.
Yes.
They will place conditions on you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed in this case, that you are eligible for judicial release?
Yes, sir.
You could be placed on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 60 months. Do you understand that?
Yes, sir.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow a sentencing recommendation of either the prosecutor or your lawyer?
Yes, I understand.
Have you had enough time to talk to Mr. Mulkey before pleading guilty today?
Yes, I did.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No, sir.
Mr. DePiero, if the case went to trial, what would the evidence show?
Yeah, the evidence would show March 16, 2026, 3:38 in the afternoon, the defendant was pulled over in Lake County, Ohio, at Som Center and Maple Grove Road. Officer on duty, wearing a uniform, driving a marked cruiser, ran the defendant's plate, found that he had an active warrant. Defendant stops his car. The officer asked him to get out of the car. The defendant said, "Why?" Cop says, "You have a warrant." Defendant then put his car in gear and drove away at a high rate of speed, exceeding 60 mile an hour on Maple Grove, which is a residential street. I think it's 35 mile an hour. Speed limit at that point, and he's crossing over double yellow lines into the opposite lane to pass other vehicles. Other reckless driving where the officers had to stop the pursuit. They were following with lights and sirens. But based on the defendant's dangerous driving, they had to stop it. About 25 minutes later in Wickliffe, that was in Willoughby, Lake County, Ohio. Wickliffe, Lake County, Ohio, about 25 minutes later, on-duty police officers observed the defendant driving his vehicle completely over the left fog line into the left-hand shoulder, passing the vehicle to the left that had to move out of the way and brake so as to not get hit by the defendant. With lights and sirens, the police were following. The defendant was approaching speeds 100 mile an hour, 90 to 96 miles an hour, driving across 3 lanes of traffic, fleeing from the police. And then he went on North Lakeland at 260th Street. He ran a red light at Babbitt, went back onto 90 going 113 mile an hour when the police called off the chase at that point. Thank you.
Thank you. Mr. Mulkey, anything to add to those facts?
No, Your Honor, thank you.
Mr. Thompson, did you hear what Mr. DePiero said that the facts would show if the case went to trial?
Yes.
Are those facts true?
Yes, sir.
What is your plea to count 2, failure to comply with the order or signal of a police officer, a felony 3?
Guilty.
Mr. Mulkey?
this is that same paperwork that we went over this morning, okay? Sign it right here. 5/27/26. That does it.
Your Honor, the defendant, Mr. Mulkey, and I all signed the written plea of guilty form. With the court's permission, I'm approaching to present that form to Your Honor.
The written plea of guilty,
Yes, sir.
did you sign it voluntarily?
Yes, sir.
You want me to accept your written plea of guilty?
Yes, sir.
I'll accept the written plea of guilty. Defendant was present when Mr. Mulkey advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept the plea of guilty and find him guilty of count 2. Failure to comply, a felony 3. I'll refer this for a pre-sentence report. Sentencing will be July 1 at 1:30 p.m. Mr. Mulkey?
Yes, Your Honor. As it relates to bond, my client would like the opportunity to be released on a recognizance bond. I believe he understands that if he fails to appear for court, that would involve a new felony charge, a felony 4 action for not showing up to court. He, as he indicated, has experience as an HVAC tech. He's a member of Sheet Metal 33 Union. He also is willing to pursue work as a welder upon his release. My understanding is he does have 5 children, ranging from ages as old as 16 years old to as young as 2-year-old. He'd like to continue to be able to provide for them. He's willing to wear a GPS monitoring system, appear at all future court appearances, cooperate fully with probation for a pre-sentence investigation. He's being properly medicated, taking his Lexpro. He does well when he's taking his medication. He wants to maintain a clean and sober life. He has a residence at 372 Haley Drive in Euclid, Ohio. He resides there with his mother. Judge, thank you.
Mr. Shapiro?
State opposes that request. The bond is set at $200,000 cash surety with conditions of GPS monitoring, EMHA, and no driving, which is warranted based on the conduct here and the facts of the case, the nature of the offense. The defendant does have prior felony convictions, F3 burglary, where he got in Cuyahoga Common Pleas Court, he got community control in 2021 with CBCF treatment. In 2017, here in Lake County, he was convicted of an F3 tampering with evidence, served 14 months in prison. Prior to that, he has resisting arrests, unlawful transactions and weapons, a misdemeanor, failure to comply. Actually, if he has a misdemeanor failure to comply, does that make this a mandatory lifetime driver's license suspension?
That's my understanding.
Was that on the paperwork? I didn't catch that part. So that would have to change. If he's got a prior failure to comply, I don't know if it's a felony or not. I'm gonna look that up right now.
I've been through this once before, and there's no distinction made between a felony and a misdemeanor failure to comply.
No.
Driver's license suspension because you have a prior failure to comply. Okay. All right.
Yeah, it would be 2921.331 subsection E.
Is that still a class 2 or is it a different classification?
Well, it says, you mean, it's class 2, it's a class 2, which is 3 to life, 3 years to life, as it states in the paperwork. What I'm worried about is, about midway down, it says, if the offender previously has been found guilty of an offense under this section, in addition to any other sanction, the court shall impose a class 1 suspension under 4510-02A1, which I believe is a lifetime suspension. We're going to look it up right now. Yeah. So this paperwork, Your Honor, I would ask the court to advise the defendant that his driver's license is going to be suspended for his lifetime because of this conviction. And we advised him based on what we had in here, that it was a 3-year to life driver's license suspension, but that is inaccurate. It's actually a lifetime suspension.
You understand that, Mr. Thompson?
Yes, sir.
It's a mandatory lifetime suspension. Mr. Mulkey, I'd ask you to take this back. And at the bottom of page 2, you have Mr. Thompson initial in the margin.
Yes, do you want to verify that your client does have this misdemeanor failure to comply in Willoughby? I mean, I'm just seeing a note, I'm not looking at leads.
And so it's just the judge wrote what medications you're on, and it says lifetime suspension, so the initial that there.
So suspended for life.
I'm looking at a note in the file, Judge. It says M1. I'm not looking at a lead.
All right, well, if it turns out that that's not the case, then it'll be a class 2.
Thank you, Judge. Thanks. Did you guys initial that? Is that what that is?
Yeah, something, and then that's his initials.
Okay. Your Honor, the defendant and Mr. Mulkey initialed where you crossed out and wrote a lifetime suspension. So did I on the approach that you presented to you.
All right, based on this offense and the history as indicated by Mr. DePiero, I'm going to revoke the defendant's bond.
Alrighty, friends, episode 298 of TCF Live today. We've got about 40 or so minutes to go. Haven't been here yet today. Let's go down to Texas and see what's going on with Judge Stevens.
Your judgment counselors, you're charged here with the 2nd-degree felony of aggravated assault on which apparently you punched somebody, a girl in the mouth, a member of your family, and caused serious bodily injury. According to this, you're looking at up to 20 years in prison. Okay. This is.
The caption on this, Judge, says 2nd degree, but it should be a 1st degree.
I'm reading this. It says a member of the defendant's family, but in the probable cause affidavit, it goes on to state that the complainant in this case is the defendant's wife.
That's correct, Your Honor.
But they have different last names.
Yes, sir.
It's no way to treat your wife, somebody you pledge love to. I've been married 40 years. I know how you're supposed to treat a lady. But anyway, this is what it alleges, unless of course she punched herself in the mouth and created serious bodily injury.
which I don't think. Arturo Puente? Where's Mr. Puente?
He's right there in the back row.
Okay. He's clear. Yeah, go. Yeah, y'all just let me know what y'all want to do. Okay, I'm sorry, go ahead.
Just the state has been off this morning. I have not had a chance to talk to Mr. Johnson about it.
Talk to him and we'll have how much time.
Just got to reach you.
Let me know. I'm gonna put this in the slab.
Yes, sir.
Bring it here.
Okay. Mr. Clerk.
Yasani Robertson.
Just that right now, the state has been up for 10 years with her and
Where is she?
she's coming this way.
Come on.
She's
Right there.
you gotta come.
Applicating evidence.
Johnson.
I'm gonna go talk to them about it. So currently the offer is a 10-year or 10 years offer and Mr. Johnson just, Ms. Robertson does not want 10 years.
She's charged with the third-degree felony of tampering or fabricating physical evidence, but this says concealing a firearm that was involved in the commission of a homicide. That's why that offer is being made.
Correct. And we're still actively investigating the homicide with her as the primary suspect, Judge.
All right. Well, that's.
In that case, we definitely.
No, this is that. Either way, that doesn't look good. Okay, how much time?
4 weeks ago.
Is that what you're wanting, or are you just?
I've made the maximum.
Well, Judge, if they're gonna indict her on a homicide case, we feel like you won't.
Well, I mean, is that what they're gonna do?
I don't know.
My words were.
They didn't
we're
say.
still actively investigating.
At this point, I guess.
But this involves a homicide.
Correct.
The tampering of evidence involving a homicide, so that's why it's been indicted as a third-degree felony, but homicide is a different crime.
Correct.
And can be looked into, and if the grand jury decides there's probable cause, then they can indict it. Anyway, you just set it for trial?
Yes, sir.
Okay, it's gonna be forwarded to trial, and we'll get it to trial. And get a resetting, have a seat there before you leave. And I see Christopher Stelly was reset, right?
He's in the
What does that mean?
Means we need to wait till
The
they.
feds aren't being polite.
We need to.
You couldn't get him, Judge. They
Yes.
left for
Put them in federal custody for?
Yes.
We don't know.
Just found out he was in there this morning, so we'll have to look into
You
it.
think it's a federal crime?
No, I don't know. Could be something else.
Alberto Toledo.
I'm working with the prosecution right now. I'm resolving this.
Where's Mr. Toledo? Just make sure he's okay.
He's, let me go grab him, Judge.
Is he outside?
Yes, sir. I was talking, but I told him, let me grab him.
Okay, I just come in and I just wanted to wave his little hand.
Okay.
So I know he's here. Alberto Toledo. Do you have something? Oh, do you? Come on in. You are Alberto Toledo? See, correct? Okay. Mr. Turk is your attorney? Abogado? See?
Yes, sir.
Right, okay. You speak English fluently, and do you speak Spanish too? A little bit. Muy poquito. All right. Listen very closely, Alberto. You were charged with, in this indictment right here, there you are. You got the attention, that's your name in this indictment right there. You're charged with the third-degree felony of obstruction or retaliation, which states that you intentionally or knowingly threaten to harm another person, that is to commit murder or aggravated assault in retaliation for that person being a public servant, namely a Port Arthur police officer. So I haven't read this. My guess is they stopped you for some reason and was talking to you, and allegedly you threatened the officer for whatever reason. This is a third-degree felony if convicted, which means you face up to 10 years in prison, which is serious. That's number one. Number two, there's a warrant for your arrest. You're in custody. The officer has a warrant. And what is it for?
Reckless driving.
Reckless driving. You can't even drive properly, I guess. So, you're going to be put in custody, but we're going to leave you over there so your lawyer can talk to you. But you're not leaving the room until you go get processed through the jail. See what y'all can do. I think when he was placed under, this is showing he was placed under arrest for reckless driving in this. So I guess that's what, in this event. Then on the way to the jail, the defendant threatens to kill him if he sees the policeman out of uniform.
Legend. He wasn't intoxicated.
Due to Toledo threatening death to me, I also placed him under arrest for retaliation. So it was out of the same event.
That's a little surprising to me, Judge. I assume that they had arrested him for that already.
Yeah. Probably inebriation had something to do with it. Or maybe not.
Leave it with him, Judge.
Okay, let me know. He's in the bullpen.
That way.
John? West. Not there.
He's signing up people now.
Sorry to hear that. Why are you here?
Yes, cases, Judge.
Is it Alan Khan and Stallions?
Yes, Judge.
Okay, let's do that. Your ad is glowing.
I know. I used to start.
2016. Who are you? Turk?
Oh,
Alan, I'm not Turk. It's Alam Tajik Khan.
yes, sir.
What is that?
Oh, my dad is from Pakistan.
Oh. Okay. PLA.
I don't speak it.
You don't know.
Yeah. I was my mother is a staffing program. I was driving.
Chukriya then.
Okay, that's a misunderstanding.
All right, well, you know what you're charged with, and we're not gonna embarrass everybody throwing it out there on the internet. It's a state jail felony, though. It's a felony, which carries with it up to 2 years in the state jail. So it's serious. It's a felony. It's the least serious felony, but still all felonies are bad. Is Mr. Gertz gonna be your lawyer?
Judge, I am sorry.
I mean, that's who's gonna be your lawyer, right? This man, Mr. Gertz? Okay, good for you. What do you want to do?
It's more time.
Okay, well, I was indicted in January. You got this 4 weeks gonna be good to figure it out. All right, anything else? Is there anything the state needs to sound in on?
No.
All right, let's reset announcement moving forward. Here, thank you. And Samantha, Joe, Scoggins. Are you still at 10430? Okay, I need your new address.
All right, Judge muted while he got that address. Let me try to bump past this a little bit.
To train it with my translator, make sure she understands.
Who is it, Castillo?
Miss Castillo.
Kataya?
Yes, Your Honor.
Where's she?
She's in the courtroom.
Come forward.
Miss Castillo. I just want to be sure that my.
How much time?
Just go long recess.
Normal in this room. Normal.
What was that? I'm
Do we
sorry.
need to get an interpreter here?
No. It's just her English is good, but it's not
Yours is
her first
not.
language, and I'm just mine is adequate. But the thing is, my Spanish is not good enough, and I just wanted to put that on.
You got it. Did you say 4 weeks?
That's perfect.
Okay,
Just
so we said 4 weeks.
Okay. If the reset. Yeah.
Here's the file. Thank you.
Hart. Thank you, Judge.
How we doing there?
Probably as much take care of everything in the world.
See what we can do, huh? If we can do anything.
I've got at least one lined up for Willie. So
That makes one.
It's you.
That makes
One out
one.
of like 20 is not a good odds.
Teacher's pet.
People in bed. And you say for sound sorry, that's what you. Hey.
You know what? I've watched the attorneys how you work here in the courtroom and there is a circle. Some of the attorneys just walk in a circle. It's in a circle. Which isn't getting anywhere, but it's amusing. It's just a circle. One way to do it. But you always end up at the same place. Except for the lawyers who can't make a perfect circle. They get it.
Difficulty is preventing the plea.
Scott, you got something?
I've got a plea.
Yeah.
See this client come forward.
Who is it?
Devin.
Devin, come on up. Desla. Okay.
Oh, it's, you need, I need to, please raise your right hand. Need for you to.
Not regular draw.
Your right arm.
They came perfect. That's what I'm
Flat right here on box.
Good to see you.
Okay, one more time. Keep it up. Same one, yes, sir. But we're in right there. I don't see anything.
You know, he grabbed your wallet when you weren't paying attention. Ryan. Scott, why got your wallet?
I wouldn't be surprised.
Okay. You got it. Be careful. Next question.
I was leaving stage advice.
Let me know if you need a few bucks. Wait for the far. 26 CR 144 is called the state of Texas versus Devin Wayne Deslon. That is you, Mr. Deslon. And on Vasani Robertson. That was you. You're clear. Did you get a resetting? Okay, you can go. Thank you. I'm gonna need a pad. You were here with your attorney, Mr. Rennick, and the state's attorney does the defendant. Waive a formal reading of the indictment and the arraignment here. Can we proceed in summary?
Good day, Your Honor.
In summary, sir, this indictment alleges that on or about November 19th, 2025, in Jefferson County, Texas, you've committed the state jail felony of solicitation of prostitution. Do you understand what you're charged with here?
Yes, sir.
This is a state jail felony, which means if convicted, you face confinement in a state jail for any term not less than 180 days or more than 2 years. In addition, a fine can be assessed not to exceed $10,000. Do you understand the punishment range you're facing? An agreement has been reached where you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 5 years in length. If I call, there's a recommendation here of 2 years. We're going to get to that in a little bit. Fine $500, then there would be terms and conditions of probation, which are normal and customary. You do well, at the end, it is dismissed. Is that your understanding of the plan? If I follow this agreement, you have no right of appeal of your case. Do you understand? That's seven. Yeah. You know. This screen is not showing data that it normally shows. But today's May 27th.
Yes, Judge.
Again, if I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this charge, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? Yes, sir. That's your final answer?
Yeah.
I'm going to show you what's marked as State's Exhibit 1. You're going to have to sign the bottom. You didn't sign the bottom of this. Here it goes. Here's the pen.
Right there.
Where it says your name. Did you sign that document?
Yes, sir.
Understand it, discuss it with your attorney? Are the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. It was. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination. Is true at stake, so help you God. Correct? State's Exhibit 1, part of the record for all purposes, is a pre-sentence report waived to it.
Yes, Your Honor, please.
I am going to follow this agreement, sir. I'm going to find that you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this offense. But I am going to defer and postpone only finding you guilt so long as you follow the terms and conditions of probation in this deferred adjudication or unadjudicated probation order that you will be reviewed with by the probation officer in a second. There will be terms and conditions of probation which you must follow. Most of those terms and conditions of probation are the terms and conditions of life that we all are required to follow. Don't commit a crime, take care of your responsibilities, etc. You must pay a fine of $500. There will be other terms and conditions of probation. Now, length of probation, there's a non-binding 2 years. What does the state say on that?
We have discussed the 2 years. State is in agreement with that.
Is that good?
Yes, Judge.
It will be for 2 years. And this is fixable. So fix it.
Sir.
Find that out for my son. Those things here. And then she'll go over all of those with you. And then you'll begin probation here in a minute. Quicker it begins, the quicker it ends. Thank you so much. Great job. We did some things that are unusual.
Finish one of the conditions at the bottom.
Mhm. And please see this lady and you'll begin probation. Good luck. Thank you.
Alrighty, friends, we're going to go to Judge O'Donnell for a new contestant there. But before we do, reminder tonight in the blind with Mike and Dan, 7 p.m. Eastern, 4 p.m. Pacific. There is a link for that in the pinned chat. If you're new to the channel and aren't familiar with what In the Blind is, it's actually not this channel. It's a whole separate channel, separate show done by me and Michael Groff. And we have no idea what we're going to talk about until we go live and it's presented to us. Thus, we are In the Blind. Fun show. Please do check that out again, 7 p.m. Eastern tonight. You can get there through the link in the pinned chat. Okie dokie, let's go to Judge O'Donnell.
Failure to appear on an OR bond. Parties are ready to go forward, Your Honor.
Thank you. Mr. Smith, go ahead.
Thank you, Your Honor. First and foremost, my client takes full responsibility for both cases here. Definitely realizes he didn't use the best judgment in the first case and not appearing for sentencing on an earlier day like he should have. And as a result, he picked up a new case for failure to appear. So he takes full responsibility in that, realizes that he should have made any and all efforts to come to court when he was supposed to for sentencing. We're asking for fines and court costs, number one, time to pay for that. And I do think my client could benefit from some sort of drug or alcohol treatment. He does understand that that will involve more local time, quite possibly in regards to that. We're asking if he be placed on probation, if that probation be transferred to his home state, which is New York. He's indicated to me that after all this is behind him, he plans on going back to New York. Thank you.
All right, thank you. Mr. Harvey, what do you want to tell me before I sentence you?
That I'm happy I'm here getting this taken care of. You know, I made some bad decisions and, you know, I'm just happy to move on with my life and start new, you know.
So your history indicates a conviction in 2014 for drugs.
Yes, Your Honor.
You were put on probation with conditions that you completed probation in July of 24, and then you pick up this case in 25. So what's been going on? Usually I see drug guys that are 1, 2, 3, 4, 5
Yeah, no,
continuously.
I got caught up with in the streets. I lost a couple friends. I started smoking crack a little bit, and then I moved out here to get away from all that shit, and I did. Oops, I'm sorry. Mind my language. So then I got caught up in the wrong place, the wrong time. I succumbed to, you know, purchasing the drug again, and I got caught, you know, with it. So, I mean, I haven't touched nothing else since then except a little bit of meth, and that was why I had a bad tox. Other than that, I'm done with all that stuff. I've been clean since. My girlfriend, she's clean. My family's waiting for me to get out of this so I can go back to work with them. And, you know, I miss my old life and I miss my friends, but I can't bring them back by doing drugs. So I've
How
learned
many
a
have you
lot.
lost because of this stuff?
I lost my car, my apartment, my way of life, some respect for myself, you know. Luckily, I still have my family.
What about people? Have you lost friends? You mentioned something like
Yeah,
that.
yeah, I've lost a couple of friends. They had an accident Like one had a motorcycle accident, a traumatic brain injury, not to do with the drugs, but that's what kind of pushed me into the spiral that I caught myself in. And then, but I've grieved, I've recovered, you know, I got my life back on track, and I'm still sorry that I didn't make it to court. I needed a little bit more time, but I realized that my bond was revoked because of the dirty talks, and I didn't know that, or else I would have turned myself in a little earlier. And I guess that's the only reason I didn't do that is because I didn't have an active phone on, and I was trying to get one, and I wasn't able to contact my lawyer 100%. So that's on me still.
What do you have to do to get your driver's license back?
I have to pay, I think, a $40 fee in Portage County and a $60 license suspension fee, I think, in another county of Ohio. And then I think I have a $175 fee in New York for my suspension there. If that's correct. I'm going to get all the information I can as soon as I get out. I mean, work with my probation officer as well, and try to get all my court costs and fees taken care of. My dad set a little bit of money aside for me to take care of some fees and such like that, as far as transfer and a ride home and to get me set up, you know, when I get back home, if and when that happens.
All right. Mr. DePiero?
State's going to join in the recommendation for community control sanctions here. We hope the defendant does get his life in order and his affairs and his addictions dealt with. If not, he can sit and rot in prison. Thanks.
All right, I've reviewed both pre-sentence reports and the drug and alcohol evaluation from last fall. I've considered all the provisions on 29, 29, 11, 12, and 13. On both cases, I'm going to place you on community control for 3 years. On the 916 case, you're going to serve 93 days in jail with credit for 48. The last 30 days, you're going to enter into the jail treatment program, complete it, and follow their recommendations. On the 1493 case, 78 days in jail with credit for 78. The remaining terms will all be concurrent on community control. When you're done with the jail treatment program, you're going to enter into the NeoCap program, complete that, and follow the recommendations. You're to have no drugs or alcohol, and you'll be screened. You're to attend at least 4 AA or NA meetings a week, and obtain a sponsor and maintain a sponsor. At the appropriate time, obtain and maintain full employment, get a valid driver's license, and pay the costs and supervision fees in these cases. Ms. Wehagen, any other terms you think are applicable?
No, Your Honor.
Mr. Harvey, do you understand the terms?
Yes, I do, Your Honor.
If you don't comply with the terms, then the state will file a motion to terminate your community control. If I find you violated, you face a potential prison sentence of 18 months on the 1493 case and 12 months on the 916 case. You understand that?
Yes, Your Honor.
Now, if you, assuming you go through the jail treatment program, complete it, go through NeoCap and complete it, then I will likely transfer your supervision to, what county do you live in?
Niagara County, sir.
Niagara County. So that's the likelihood if you do what you're supposed to do.
Okay.
Anything else, Mr. DePiero?
Was there any discussion of forfeiture either? If there was any contraband drugs?
Yeah, anything subject to forfeiture is forfeited to the state. Anything else, Mr. Smith?
No, Your Honor.
All right, we adjourn.
All right, thank you.
Okay, so.
So Mr. DePiero is a very interesting prosecuting attorney, in my opinion. Your Honor, the state sincerely hopes that this defendant will get his life together. Therefore, we join in the recommendation for community control. But if he doesn't, let him rot in jail. You don't often hear them say, let them rot. Anywho, let's go to Judge DeSanto, and we will finish our day there.
Good morning, Your Honor. Your Honor, John Goldclaw, P 30758, on behalf of Mr. Bart.
Thank you, Mr. Barton. Your name for the record, please.
Barton.
All right. So today's the date scheduled for sentencing, as your client was originally scheduled for sentencing February 26th and failed to appear for that sentencing.
That's correct, Your Honor.
And so we're here today.
That's correct, Your Honor. Your Honor, we reviewed the pre-sentence report. I've also had some further discussions with Mr. Barton. Mr. Barton has also provided me with further documentation. I've been in contact with him on Ms. Shine. During the previous matters, I forwarded to Ms. Shine the reports as well as he's presently on probation in the third circuit court. That probation information was provided to Ms. Shine as well. If I may approach Your Honor, Mr. Barton has some documentation that he was to present
Okay.
of his steps that he has taken as probation. Awesome. So she has on those matters. Your Honor, we have reviewed the pre-sentence report. There are no additions or deletions other than Mr. Barton is still looking for employment for a period of time. He was for all intents and purposes homeless. He has successfully completed some of the probationary purposes. He is still has numerous attempts to obtain gainful employment as a CDL driver, CDL driver. He is already been looking into what they call
Second chance company.
second chance companies.
Check this out on that.
Which you learn about. These are companies which basically,
Right. They employ individuals that have felony convictions and allow people a second chance.
that's correct.
Correct.
Just got permission from Judge Baker to two companies that are interested in me to go out of state 3 to 4 days. It's on just the letterhead, a description about what I'm going to be doing, and as long as it's going to interfere and my having to do behavior therapy, that counselor therapist said that I could do video chat if I cannot make this scheduled appointment. Still looking up my community service. I've only got 2 hours. I'll get it done. But I'm going to get that done.
When were you sentenced in the felony matter, sir?
Your
January.
And you only have 2 hours completed?
Yeah.
Why is that?
You know, yeah, I guess learning thinking about myself and I'd say no smoke, just depression and no motivation. That's the truth. You know, but now that I've been going to counseling, therapy, and I'm feeling better about myself. You know, I companies, I get my research done. 80 hours is a lot. You know, and I'm going to do it.
It is a lot, but if you do a little bit every month, then it's not a lot.
Exactly. Before I didn't have the motivation, but now I do.
Court order isn't motivation?
No, not for me, it was, I'm sorry.
Okay.
I'm just being honest.
No, that's fair.
How much people said last time I was there, thanks for listening to me, you let me come. But you are, so I appreciate that.
Why didn't you show up back in February for your sentencing, sir?
Because I don't live at, I lost that house and I was saying my daughter before they leave. And apparently I did to notify the court that my address was 1844. I don't believe I did.
You did not.
And
nor did you look online to see when your sentencing date was, nor did you contact us to let us know, oh, I missed the date.
I did not.
Or when's my date?
I assumed I talked to Mr. Hollier about it when we were downtown. He said he would talk to him. And he would get back to me.
Him meaning Mr. Goldpaw that you're pointing to? Okay.
And I don't know speech impediments.
Oh, that's okay. Just for the record, it can't see where you're pointing.
I understood he was perfect.
I understand that, but if somebody is looking at the transcript, they don't see that.
And Mr. Holly looked at me and said, well, if you don't hear nothing from me, everything's good. Because this is not like Judge to have this happens to let a case go. And he, you know, for a second, he thought you let it go. And I swear, we that's what you recall. Talk to the man. And he goes, well, let me double check on things. And if you don't hear nothing from me, okay, just go and take care of business as usual. And that's what I did, but I'm not putting nothing on him. I'm just saying, I found out later on, it kind of got mixed up after it was separated, because you wanted to see what was going on with that felony case of mine. And it just got lost temporarily, from my understanding. And that's how I got the warrant out for my arrest.
And Your Honor.
But I didn't get picked up. The Wyandotte police seen me coming out of my chiropractor's office on February 17th. And they, as I got in my car, Wyandotte police, they you know, swooped me up, said, hey, you got a warrant out for your arrest, ran my name. And I said, hey, Tim, how's it going? How you been? And they said, well, take care of the warrant. They didn't arrest me. And okay, the warrant. And I went and talked to the probation officer, and she seemed very nice about it. So okay, we'll set it aside. And I gave her my discovery papers of my case, and I give you these things that I'm completing now. So I mean, just.
All right.
Your Honor, if I may, along with that, Ms. Shannon and I have been in contact throughout the matter. I provided her with the probation documents.
Sir, please remove your hat. You're in court. Thank you.
Probation documents out of the court. We were in contact. I forwarded, but it appears because he had moved and had a different address and his email wasn't active, I guess, for a period of time that he got the information that I had forwarded with the PSI.
Right. Sir, have you updated your address?
It's still 1844 Monty Street temporarily, and so she makes up her mind and she's moving to Texas. I let my probation officer know. He said keep him informed. I'm on a list for shelters. And matter of fact, I got to go next door to Wayne Metro, sign paper. Next on the list up is that available where I'm unemployed, and it's a process.
And sir, your matter that you're on, so your probation in Third Circuit Court, is that treatment court or is it straight probation?
My probation through.
I had a copy here, Your Honor.
Right, so is it, are you participating in treatment court, mental health?
You got a paper right in front of you.
You are participating in treatment court? No, not outpatient treatment. I have your information regarding.
Okay, that's outpatient. Yeah, okay, I know what you have in front of you is what they recommended, and that's what I'm doing now.
Okay, so you're on general probation.
That's correct. That's what I was trying to.
Okay.
I don't understand term general probation.
Well, because treatment court is a different type of probation. That's treatment based. And given what I've read from your provider, I'm a little bit surprised that treatment court wasn't something that you were participating in circuit court. I don't think I don't know if it would be beneficial for Mr. Barton to participate in treatment court for this matter, given he's on felony probation and he's already taken these steps regarding his treatment. If you test right now, sir, what's in your system?
Picking out one. So.
All right. After reviewing the report, the recommendation, hearing from counsel, from Mr. Barton, the court does not find that there's reason for grounds to depart from MCL 769.5. As Mr. Barton's not eligible under 771.1, he's on felony probation. Is this the court copy or is this your only copy, sir?
No, that's my court's right.
Okay. And congratulations, sir, on completing your outpatient treatment. Are you still continuing your CBT?
Yes. Sign on.
All right.
Requirements.
So, okay, the court's going to find our order fines and costs only. I'm gonna waive the fines and costs and the warrant fee. You're all set, sir.
Thank you.
All right, good luck to you.
Thank you very much, Ryan.
You're welcome.
Okie dokie, friends, that will do it for this morning. Thank you so much for spending your morning with me. We'll be back tonight over at In the Blind, 7 p.m. Eastern, 4 p.m. Pacific. If you hang tight, as soon as I end this stream, YouTube will take you over there so you can set a reminder. And of course, we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, half an hour early for channel members. So look forward to seeing you tonight and most certainly tomorrow. I hope you all had fun. Thank you so much. Take care. God bless.